what is the urgency?
Request has been behind the bar about 3 months. The charge is submitted.
No, withdrawal also you are mentioning before the senior court, same rules apply.
May I please, Lordship? Lordship, CD may call for a matter relating to murder, Lordship.
Heard Mr.
A. Alam on behalf of R.A. Ahmed.
A.R. Rahman, learned counsel for the petitioner, also heard Ms. A. Begum, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application.
Lordship,
Hence-
along with medical report.
Hence, call for the case diary along with post-mortem report, examination report. List this matter when we can. 4th of November.
Keep obliged.
May I please, your lordship? It's a 483 application petitioner before your lordship. Behind the bar, 40 days, lordship.
So all the cases are handed over to CBI lordship, so at present, I cannot.
Oh, this matter is also handed over to CBI.
No, this matter is not handed over to the CBI lordship as per my.
Okay, we'll
understanding.
call for the case diary.
Yes, lordship, 40 days, 60 days statutory period, lordship. Today's 40 days is over, lordship.
But we don't know the progress.
Yes, lordship. So your lordship kindly peruse the
No,
Azahar lordship. I am only the employee of that institute, lordship. I am no.
not
connected-
not without going through the case
Yes,
diary.
yes, lordship.
Heard Mr.
24 to the-
R. Borua, learned counsel for the petitioner, also heard Ms. A. Begum, learned additional public prosecutor. Perusal of the case diary would be necessary. Call for the case diary. Fixing
Lordship on 25th.
25th November for 25th October for case diary.
Give me, lordship.
May I please, your lordship, application under 483, my lord, under section 3182 of the 24, my lord. Today is 73 days, my lord. They have a love affair, my lord. A girl child has been born out of their.
Case diary. Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Ms. A. Begum, call for the case diary. Same order থাকে না?
My lord, can be on 21st,
Is it for
22nd.
22nd.
22nd for the case diary?
Obliged, my lord.
May it please, your lordship. Lordship may call for the diary, madam. NDPS case.
Heard Mr. N. J. Dutta, learned counsel for the petitioner, call for the case diary. List this matter.
Lordship 6th of November.
6th of November.
I'm obliged.
May I please, your lordship? Lordship, in this case, lordship, NBW and PNO was issued, lordship. Subsequently, he surrendered before the learned court below, lordship. And with a bail petition, and the bail petition was rejected and remanded to the judicial custody.
Why it was rejected?
Rejected, lordship will find at case 46, lordship.
What is your case?
My case is that, lordship, I have filed a petition, lordship. Lordship will find in the page 41, that is the pleadings I have taken in the petition, lordship. That's my case, lordship. I was not, originally I was from Meghalaya, lordship. Subsequently, I married to a girl from the Gwalpara district and I stayed Gwalpara permanently. And I used to work in,
No, we
Full.
will call for the status report. At what stage the case is pending now?
Yes, is the lordship, total eight accused, there are total 8 accused, lordship. And till date, 2 accused has not appeared, my lord. And
But because of your absence,
no, my lord, and other 2 accused are also there.
you are absent since 2000 and
And non-bailable warrant issue was issued on 8/7/2022, and PNA was issued on 21/9/2023, lordship. And I come to know when, lordship, I went to
okay, we'll call for the scan copy.
lordship,
Heard Mr. J. What is your name?
J. Abbas, lordship.
J. Abbas, learned counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. Perusal of the scan copy of the case record of GR case number 1526/2016 would be necessary for consideration of the instant bail application. Hence, call for the same registry to take steps for requisitioning the scan copy. Let this case be listed again on 8th November.
Lordship.
8th November.
Obliged, my lord.
May I please, your lordship? Your items 6 and 7 are arising out of the same FIR. Lordship will kindly see here, lordship has an occasion in dealing with this case earlier also. Lordship will find the FIR in page number 2222, annexure 1. The allegation is regarding disproportionate asset, lordship, against one Santosh Kumar Chaudhary. And the petitioner before lordship happens to be the wife of the FIR named accused. Now, lordship, I have made a contention before lordship in paragraph number 8, page number 7, lordship, where this petitioner was thoroughly interrogated. My anticipation, lordship, is in paragraph number 8. She was thoroughly interrogated, and again, she has been issued a 41A notice, lordship, for appearing before the IO today itself, lordship. And lordship, she is ready to appear, she is ready to cooperate. Only thing is, lordship, we are looking for some protection, lordship, because there is a strong anticipation on the
My lord,
Why are you anticipating?
lordship will kindly see my paragraph number 8, lordship. I was thoroughly interrogated, lordship. I appeared, I was thoroughly interrogated 2 months back. And now after 2 months, I am being served with a 41A notice, lordship. Out of nothing. And lordship, I kindly see that this is a case where the prosecution is not making any case that there has been an abatement to the commission of the offense, lordship. The 41A notice is,
The allegation is against your husband.
yes, lordship. And this honorable court was pleased to allow him to go on bail, lordship. That I have already annexed, the lordship will kindly find in page
Yes.
number 43.
lordship, you submit.
No, let me kindly complete my submission. Page number 43, lordship will find the bail has already been granted to him and he is cooperating with the investigation. Now, lordship, will
Your-
see,
Your husband has appeared before IO.
yes, lordship, several times.
Okay,
And still now also he is appearing.
okay.
It is not that he has not appeared, he has appeared, and even I have also appeared, lordship. If your lordship may kindly see paragraph number 8, lordship is clear, it is very clear that the petitioner states that on one occasion, the eye of the instant case has called the present petitioner to the concerned PS and interrogated her at length. Now, after 2 months, that too in the
Now, suppose a person is interrogated in connection with a case.
lordship,
His interrogation is further required. What is the procedure?
160, lordship,
Not
160.
41
because
only if he is
If
accused.
he is there
Ac-
named accused,
Okay.
he is not a named accused here. And 107 IPC has not been taken into consideration. It's a DA case and they are investigating it and absolutely in a different footing. Lordship may kindly see there is a finding of this honorable court, annexure 5, page 50.
No,
Lordship.
okay. The main allegations are against your husband,
Husband,
who is cooperating.
yes, Lordship, absolutely. Every day he has been called for, he is appearing.
What is your submission?
Lordship, lordship, my
Yeah.
submission is that there is no relationship of this petitioner in this case, lordship. There
Then
is-
why,
there-
wha-
Let
then
me
why is
submit,
called
let me
for?
submit, let me submit. Let me submit, you have finished, let me submit.
Yes.
Lordship,
Don't get aggressive.
no, this is not a case of aggression. This is my right. Lordship, they have no relation with this case. Investigation is going on, lordship. And this is the prerogative of the investigation officer, lordship.
court doesn't interfere with investigation. They were required, that's why we are not arresting a lordship. Yeah, we have not added the section 12 in this case, that is abatement lordship. That's why we have not arrested. And this petition is very much premature, lordship.
Not at all.
And lordship, there is a decision also, lordship. They must ask, there are two conditions of anticipatory bail, lordship. There must be a non-cognizable offense, cognizable offense and a non-bailable offense. And there must be a definite apprehension by the petitioner's lordship. In this case, lordship, nowhere their names are mentioned, whether they are involved in this case, there are no mention in this case. There is no evidence brought by the petitioner that their names are involved in this case, lordship. And there is a decision of our contrary bench also.
Now my brother is not coming with a decision of the Supreme Court, which says very clearly that after 14 days of the investigation, no 41A notice can be issued. That judgment has not been placed before this honorable court.
Lordship, lordship, here is.
What is this?
It doesn't mean the section 41 notice doesn't mean that the accused, they are accused in this case, they are being arrested, they will be immediately arrested, lordship. It doesn't mean.
Let- Let in that case, the undertaking given by the PP be recorded. That they will not be arrested.
I'm not bound,
I'm all-
I'm not bound to instruct the IO. IO is independent agency.
There is no question of,
It will come
there
to
is no
trial,
question
lordship.
of,
It is done right or
lordship,
wrong, it
here
will come
is-
in the trial, lordship.
just a
Not
moment.
at-
Here is no
Okay.
question of giving any direction to the IO. Question is, what is the
Let me
parameters
submit
of the
now.
law?
Mr. Johnson, let me submit.
You have already submitted.
I'm submitting, no, I'm not finished.
Carry on,
Lordship,
please.
the head note, lordship, finding of the court, lordship. The court found that the application of pre-arrest bail was non-bailable as the applicant failed to demonstrate a reasonable belief of arrest in connection with a cognizable and non-bailable offense. The court emphasized the need for the specific details and evidence to support the apprehension of arrest. The issues involved, the main issues were maintainability of the application of pre-arrest bail under section 438 without concrete evidence of reasonable belief of arrest in connection with cognizable and non-bailable offense. Restitution in the court emphasized that a prima facie case must be made to demonstrate a reasonable belief of arrest in connection with a cognizable and non-bailable offense for the court to exercise its power under section 438 CRPC. Specific details and evidence supporting the apprehension of arrest are specific. The decision, the court concluded that the application of PAS which was not maintainable. Here is a similar case. There are many-
Then why 41A notice was issued?
Lordship, that is the prerogative of.
No, it
No.
is not the prerogative.
That has,
I cannot right now question.
because you issued for, you could have issued notice under 160.
Case diary maybe.
Okay, we are calling for the case diary.
Lordship may kindly call for the case diary and Lordship may kindly protect me because I am to appear.
Right now, there is no.
No, there is strong
immediate-
apprehension,
immediate
Lordship.
apprehension of-
There is
they
strong
have-
apprehension
they have
because
failed
Lord,
to-
just a moment, now I am submitting. Now you please stop. You have completed your submission. Let me submit. Lordship may kindly come to page number 7, Lordship.
Okay, no, I am giving you protection.
Let me appear today, Lordship.
Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr.
DJ Burman,
D.
DJ Burman,
P. J. Burman, learned additional public prosecutor,
Assistant Special PPCM Vigilance.
learned assistant special public
Special
prosecutor,
PPCM.
CM Vigilance. This bail application, this anticipatory bail application has been filed by the petitioner under section 482 of BNSS, 2023, apprehending her arrest in connection with CM's Vigilance PS case number 4/2024 under section 13 within bracket 1 within bracket small b /13 within bracket 2 of the Prevention of Corruption Act 1988. Stop. The gist of accusation in this case is that the husband of the present petitioner was serving as an AB constable in 6th APBN, Assam in the year 1999. And he was transferred and posted in 1st APBN, Dakur Bhita, Gwalpara on 18/3/2015 2005 on promotion as ASI slash steno. Stop. Next para. On 2/4/2024, one inspector of police of CM's Vigilance Cell had filed an FIR before the officer in charge of CM's Special Vigilance Cell Assam, interiorly alleging that on the basis of a complaint received from one Partho Gogoi to the effect that the husband of the present petitioner had collected money from government employees by intimidating them and has had accumulated huge properties in Bihar and Guwahati. Stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR, as the specific allegations has been made in the FIR only against her husband. Learned counsel for the petitioner has also submitted that in the meanwhile, the husband of the petitioner has already been granted anticipatory bail by this court in
That is
AB
in-
case number 1012/2024 on 24/2024. Stop. It is further submitted that the husband of the petitioner is cooperating with the investigating officer. Learned counsel for the petitioner has also submitted that the petitioner was thoroughly interrogated by the investigating officer of this case. However, she has been served with a notice under Section 41A of the CRPC to appear before the IO investigating officer today itself at 11 a.m., which has caused apprehension to her of being arrested and of getting harassment. Hence this case. Stop. On the other hand, learned additional public prosecutor has submitted that the learned assistant special public prosecutor CM Vigilance Cell has submitted that the petitioner is in no way involved in the case with the present case. And it is the prerogative of the investigating officer to summon any person if his or her presence is required for the sake of investigation. He has submitted that no apprehension is there of getting arrested. No apprehension of the petitioner getting arrested in this case is there, and hence the application filed by the petitioner is premature. Stop. As 41A notice has been issued to the petitioner, which is issued to a person against whom a reasonable complaint has been made or credible information is received. Hence, apparently appears that the apprehension of getting arrested by the petitioner is not without any basis. However, Perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary. Stop. In the meanwhile, as learned assistant special public prosecutor has submitted that the petitioner is in no way involved in the present case. The you will appear before
Yes, yes, Lordship.
when
Today itself,
today
today itself, Lordship.
the petitioner is directed to appear before the investigating officer in pursuant to the you may not appear at 11.
As early as possible, Lordship. Because it's a, this
What was
proceeding
the
is
last one?
on streamline, Lordship, and
To the in person to continue. Investigating officer today itself
today itself.
and cooperate in the investigation. If she does so, in the event of her arrest in connection with the special CM, in connection with
CM's
special
4 of
CM's
2000
vigilance PS case number 4 of special
2024, Lordship.
4 of 2024, the petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority with following conditions, number 1 and number 2. Let this case be listed again on when can you bring the case diary?
After 26, Lordship, there's some difficulty for me from 22 to 26, Lordship.
29
Lordship, on 30, similar case is fixed, Lordship.
on 30 November 30 October
30 October, Lordship.
30
30
October 2020.
In some other case, CD has already been called for. 7 is also same, Lordship. There is another matter.
7
Item number 7, Lordship.
11.
Similar matter. Here, Lordship, the petitioner is the mother of the earlier, the mother-in-law of the FIR named accused, Lordship. She has also been served with a 41A notice. Earlier, she was served with a 91 notice. And I have completed
present petitioner is mother-in-law.
mother-in-law of the FIR named accused, Santosh Kumar Chaudhary. 91 notice was issued to me, Lordship, and I have complied with this. Lordship, I am a resident of Siliguri, Lordship. And my present health conditions are not so good that I can travel so long, but I will appear, Lordship. Only I want 2 days time for appearing. I will appear, I will also cooperate, Lordship. I want some protection from this. court,
Same
Lordship.
order. In place of what petitioner is husband, in place of husband, right? Petitioner is son-in-law of the accused is son-in-law of the present petitioner.
Lordship.
Wherever husband is used,
Finally,
use
accused is the son-in-law of the present
son-in-law of
petitioner.
the present petitioner. Aru eta para add kori dibo. You were also interrogated.
Yes, Lordship. I was served with 91A notice.
Interrogated jot
No,
ase.
she was not interrogated, Lordship. She was served with a 91A notice.
That interrogation paragraph mention a different paragraph.
91 notice I was served with. I have
Learned
complied with
counsel
it,
for the
Lordship.
petitioner has submitted that the petitioner was served
With the notice
in
under
notice under section 91 of the
CRPC.
CRPC for production of certain documents, and
And I have complied, Lordship.
in pursuant to the said notice, she has complied with by producing the documents required by the investigating officer. Remaining, everything would remain same. Last order is she is directed to appear before the investigating officer within 7 days.
Lordship.
Within 7 days from the date of this order, everything else remains same.
Deeply obliged, Lordship. Deeply obliged.
Item 3.
Yeah, please, Lordship. FIR page 8 Lordship.
FIR page,
Page 8 Lordship. Annex 1.
yes. It is in the stage of trial. Trial is going on.
Already examined.
Victim is examining. Victim is examining.
Victim is examined. 355 days behind the bar Lordship, the petitioner.
How many witnesses have been examined?
For the schedule.
And so far, my Lordship, instruction goes Lordship. Poxo court is not, is closed in Tamulpur Lordship,
Poxo court is?
closed Lordship. Not taking any, not functioning Lordship. So
Why?
I'm not aware Lordship why, but so far my instruction goes Lordship from the client Lordship. Not functioning Lordship. So only one witness has been examined. That is a victim guard Lordship under 164 CRPC.
No, whether no presiding officer is there, for what reason the trial is not going on.
That I am not aware Lordship.
Now, what is your submission?
Submission is there Lordship. If I was filed after 5 days of the alleged offense Lordship.
No, not on merit.
Uh,
Merit trial court will
Trial
consider.
court Lordship.
Mr. Borua, what is your submission?
Allegation is lordship. Here, once he's saying lordship, that some naked photo was taken and that photo.
One portion is at page 13. The allegation is that the petitioners were traveling in a commercial vehicle or something.
Case diary is there.
The petitioners, all the petitioners were traveling in a vehicle or something. It's a commercial vehicle. And from the back seat of the vehicle, 31 kilogram of ganja has been recovered. Also.
What was the vehicle?
The vehicle is a commercial vehicle. Also, the number is given here.
Commercial
it's a vehicle, tempo.
means?
Tempo vehicle also. The number is AS25CC 1887. And in the forwarding also same thing has
No,
been.
is it a passenger vehicle or
It's a
goods carrying vehicle?
No, it's a tempo, it's a passenger vehicle. So as per
Passenger
my-
vehicle or goods carrying vehicle?
It's a passenger vehicle as per my instructions. And there are other, as per my instruction also, there were other passengers also in the vehicle and the driver was also there. And this, why these 3 petitioners has been chosen and picked up, it is beyond understanding also. And the possession, the recovery has not been made from their exclusive possession loss. It is specifically mentioned in the FIR as well as in the forwarding. And it has been recovered from the back seat of the vehicle also. And in the vehicle, it's a commercial passenger carrying vehicle.
What was recovered?
It's as per forwarding and FIR 31 kilogram of ganja. 3 petitioners are there also.
Where is the seizure list?
Seizure list, also, I could not get the seizure list.
Yes, Mr. Borua, anything?
Kindly come to page number 13.
Yes.
Page number 13, middle portion, madam. After 20 minutes, a vehicle tempo bearing number so was intercepted with 3 people inside the vehicle. All necessary procedures under NDPS were followed. The vehicle was searched in presence of witnesses, during which 31 kg of ganja was recovered from the back seat of the vehicle. Only these 3 accused persons were in the vehicle, my lord. And from the back seat, my lord, 31 kg was ganja to be recovered. It is seized from their possession, my lord. It is pending for collect the accessory.
Lordship, as per my instruction, Lordship, there were other passengers also there, Lordship, in the vehicle. Inside the
Whether
vehicle.
there were other passengers?
But apart by judge,
No, in the case diary, we will find out.
I have not found, my lord, that there were other persons also.
As per my instruction, Lordship, they were simply chosen and picked. And the recovery was also made from the back seat of the vehicle, also, not from the exclusive possession of either of the present petitions.
As far as regard is concerned, they recover from their possession. This is from their possession.
No, it is seized from back seat of the vehicle.
One of the 50 passengers were there.
No, that is my query. Whether only 3 passengers were there.
Only 3 passengers were there. There were no other.
Then assuming lots of, it has been assuming, do not admitting
Commercial positive. Then there are time to investigate. The officer report come.
lots of.
No, no. Question of, he is not challenging whether it is ganja or not. He is saying that you were only passenger
Yes, lots.
and it was found in the
Back seat
passenger
of the-
vehicle from the back seat. So there has to be something in the case diary to link whether driver was arrested.
These 3 accused persons were present, my lord, as per the case diary and vis-a-vis my lord, FIR, my lord. In my lord, I am going to my lord.
In the FIR also, lots of in the forwarding also, no mention is there who was driving the vehicle and all also. And specifically mentioned from the backseat of the vehicle also.
You go through the FIR, go through the case diary. If there is any, I'll go through the case diary.
Lots of. Lots of, it is, law is settled lots of that, it should be exclusive and absolute possession of the petitioners also.
No,
Assuming
if it
also.
is found in a passenger vehicle, there has to be something to link that recovery with that passenger.
And if from the face of the FIR, also it is clear it's a commercial passenger vehicle also. 25cc 1887.
Part likhi rakho. Her,
And one more submission also.
yes,
The husband of the accused petitioner number 3 probably. Yes, Lordship, the husband of the petitioner number 3, he has expired, Lordship. I have the date
no,
certificate.
that will not help you.
Lordship, this is just I'm making a submission, Lordship.
Heard Mr. D. Das, learned counsel for the petitioners. Also heard Mr. R.J. Borwa, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioners, namely Baliram Labha, Usuri Rabha and Saberi Rabha, who were apprehended on which date you were arrested?
Lordship, on 7/8, Lordship.
On 7/8/2024 in connection with Polaswari PS case number 274/2024 under section 20B2C/29 of the NDPS Act, 1985. The gist of accusation in this case is that on on 7/8/2024, one Rekhob Bora, SI of police, had lodged an FIR before the officer in charge of Polaswari police station, inter alia, alleging that on 7/8/2024 at about 5:30 a.m. an information was received by the officer in charge of Polaswari police station that some persons were transported,
Apart from them, my lord, there were no other people. It's revealed.
that some persons were transporting some drugs from Gorilik side to Polaswari. Stop. On receipt of the said information, a Naka checking was arranged and a vehicle within bracket tempo bearing registration number AS25CC 1887 was intercepted with the accused persons inside the vehicle. On search of the vehicle, "31 kgs of ganja was recovered from the said vehicle stop." Learned counsel for the petitioner has submitted that the petitioners were the passengers in the said vehicle, and the vehicle was a passenger vehicle, and they were unaware of the contraband being carried in the said vehicle. It is also submitted by learned counsel for the petitioner that the petitioners were not in conscious possession of the recovered contraband, as the same was recovered from the back seat of the vehicle, which was a passenger vehicle. Learned counsel for the petitioner also submits that the petitioner number 2, whose husband has expired,
It's number 3, Lordship.
the petitioner number 3, who is a woman, had lost her husband while she was in custody.
Yes, Lordship.
While she was in custody. In support of his submission, he has submitted the death certificate
It's a certificate issued by the government Gambura.
of the husband of the petitioner number 3 issued by the government Gambura. Stop. On the other hand, learned additional public prosecutor has submitted that the contraband recovered in this case is of commercial quantity, and hence the embargo of section 37 of the NDPS Act, 1985 would be applicable in this case. He submits that the contraband was recovered from the conscious possession of the present petitioners, who were the only passengers in the vehicle from which the recovery of the contraband was made. He has vehemently opposed the grant of bail to the present petitioner. He has also produced the case diary of Polashbury PS case number 274/2024. You give me the case diary. I'll write the orders in chamber. If anything is there against you, your bail will be rejected.
Lordship will kindly consider that they were not in the conscious position of that.
I'll go through it.
Lordship, may I submit one judgment of the Honorable Supreme Court regarding conscious positions?
This matter pertains to lordship, Boxer lordship. And city was
Shashi, what is the?
But lordship, I'm not naming the FIR and the vehicle scooty registration numbers AS01E 6774 that has been recovered earlier. So subsequently, I was arrested, lordship, and I'm behind the bar for about 51 days.
Charge sheet submitted, you go to the trial court.
There is no.
Heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
102/2024, dated 23/9/2023.
In view of the fact of laying of the charge sheet, this bail application is disposed of with an observation that the petitioner may approach the regular court and may pray for regular bail before the said court. if so advised.
Deep learning.
Item 50,
Please, your lordship.
It's a POXO case. Lordship, this is a 483 bail application, Lordship. Today, 49 days in jail custody, Lordship. Intermediate quantity that too not recovered from this two petitioner, Lordship. FIR, Lordship, will find on page 15. Specific name, two person, Lordship. Aminur Rahman and Vicky Hanari. Two Lordship, drugs was recovered from them, Lordship.
What was recovered?
Heroin from two-person Lordship name, Aminur Rahman and
How-
Vicky
how-
Hanari.
How much heroin?
Heroin Lordship were from one Lordship 11.26 gram and from another that is on 6.14 gram Lordship. I've annexed the Lordship seizure list that is on page 19 Lordship. In the FIR Lordship, appreciate one aspect Lordship, the accused person who are arrested then and there Lordship, they have not Lordship mentioned any other person involvement Lordship. Now Lordship,
Why you were arrested?
yes, Lordship. That's the forwarding report. I have annexed that is on page 17, Lordship. Nothing has been recovered from this petitioner, Lordship. Ground of arrest can be shown, can be perused, Lordship.
Yes.
Common Lordship, that is during the course of investigation, sufficient evidence found against them to commission of the crime in connection with the case, Lordship. Nothing was recovered from this petitioner. The second grouse, on the basis of the statement recorded 161 of Vicky Henry and Aminu Rahman, these two people were also involved in the commission. Lordship, then it's barred by 67 of the NDPS Act, Lordship. The statement of the Lordship co-accused is not admissible in evidence. That part is gone. The third Lordship, the arrested accused person were also engaged in selling and transportation of suspected heroin since long. No previous case is mentioned in the forwarding report, Lordship. They have said they have Lordship engaged in other cases, Lordship. That was not mentioned in any previous case, Lordship. No previous track record, Lordship. If the accused person is not arrested, there is there is a possibility of sale of drugs at that person in jail, Lordship. With the, on mere suspicion, Lordship, you cannot detain a person,
He is
Lordship.
there.
Is there in office?
Lordship, the person who were arrested in the named in the FIR, they were released on bail. That is on page 20, Lordship page.
Or the person from whom
Yes,
recovery-
they are released on bail, Lordship. Page 20, Lordship.
page
Page 20, Lordship.
by the trial court.
Yes, Lordship.
Then why you were not released on bail?
That Lordship, kindly peruse that Lordship order, Lordship. Bottom part is more interesting, Lordship. That is more specific. It is further revealed that the investigation of the case has progressed considerably, and the accused is under detention for a sufficient period of time. That is recovered from the person who are in detention. There is a sufficient progress has been made, Lordship. That is related to the person recovered is there, Lordship. Since recovery from them, Lordship, that is applicable to them because, Lordship, they are in detention. Recovery is from their position, Lordship. The recovery, nothing from my position, Lordship, not from my concise position, Lordship. They cannot link with this petitioner. With that, Lordship, they are involved in this case, Lordship. These two petitioners, now, while rejecting my bail application, there is, then page 22, Lordship, and relevant portion on page 23, Lordship, contradictory on the both sides, Lordship. In the first bail order, Lordship, they said, Lordship, investigation is progress much. Here, Lordship said the investigation was not progress, Lordship. Still is going, Lordship.
What is your name?
My name is Lordship Rafizul Islam, Lordship.
And where is the bail order of co-accused?
That is on page 20, Lordship.
20.
20, Lordship. Even I have annexed this court, Lordship, this court order, Lordship. if
Vicky
there is-
and one more was there.
They were also released on bail, Lordship. Aminur
Yes,
Rahman, that is
Mr.
there
Verma,
on there.
when the main accused have been released on bail.
He make a finding by Lord, the FIR, my lord. FIR, my lord, it was lost on my lord.
3-6,
2024.
FIR is at page.
page 15, Lordship.
Yes.
And my lord, on the basis of the statement of the asset accused person, my lord. That can be done by the during investigation, man. Because
Where is that in the FIR lordship statement of this accused person lordship?
during investigation, where my lord, somebody is arrested, man, kilometer contraband. The investigating officer will definitely man enter from there, where from there, my lord, obtain the my lord, this narcotic drugs, man. And who are the other people involved, my lord, along with them. These are the mother part of investigation, my lord. Now they have revealed the name of this person. Then, my lord, he was arrested. Also, my lord, nothing has been recovered.
Yes.
Whatever is there.
Okay, heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R. J. Barwa, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Rafizul Islam.
My lord, one more thing, this person who was arrested in quarter of 28 my lord. Contraband recovered on 3/6, my lord. There is a my lord trial for rejected in bail application, stating that my lord. The investigation is still going on, I ordered it at 1700.
Who has been detained behind the bars since 28/8/2024 in connection with Tejpur PS case number 318/2024 under section 21B small b /29 of the NDPS Act, 1985. The gist of accusation in this case is that on 3/6/2024, one Chanakya Das, SI of police, had lodged an FIR before the officer in charge of Tejpur police station, inter alia, alleging that on receipt of an information through reliable sources, two persons, namely Aminur Rahman and Vicky Hainari, were arrested, and from their possession 11.26 gram and 6.14 gram of heroin was recovered respectively. During the course of investigation
Even it's my lord with container. Again,
with container
and 6.14, that is without container.
11.26
11.26 with the container and 6.14 that is without container.
he is saying same thing.
No, lordship, he's saying lordship for.
You are not
Sorry,
listening properly.
Sorry, lordship.
Excited.
After 11.26 gram, right, with container. During the course of investigation, the arrested accused persons also disclosed the name of present petitioner as involved in selling and transportation of the suspected heroin since long time. Learned counsel for the petitioner has submitted that the accused persons from whose possession the recovery has been made in this case, both the accused were granted or one of the accused?
Both the accused granted bail, lordship.
Were granted bail by the trial court on 16/8/2024. Stop. However, though no recovery has been made from the present petitioner, he is languishing behind the bar merely on the basis of the statement of the accused persons who are already released on bail. Stop. The petitioner, learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 49 days. And considering the facts of this case, they may be allowed to go on bail. He submits that the petitioners are ready to cooperate in the trial with the investigating officer. On the other hand, learned additional public prosecutor opposed the grant of bail to the present petitioner on the ground that the case diary which was called for is not available before the court. He has also submitted that the present petitioner was arrested only on 28/8/2024, much later than the accused persons who were already released on bail. And therefore, the investigation with regard to them is still under progress. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record. It appears from the record that no recovery of any contraband was made from the present petitioner. And it also appears that he was mainly arrested on the basis of the statement of the accused persons from whose possession the contraband was recovered. Stop. Both the persons from whose possession contraband was recovered are already granted bail. Stop. Moreover, the petitioner has also been detained, has already completed. Moreover, the petitioner has already completed 49 days of detention. Hence, considering the facts and circumstances of this case, as well as period of detention, his further custodial detention does not appear to be necessary if he cooperates in the investigation. In view of above, the above named accused person is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Sonitpur, Tejpur, with following conditions. Condition number 1 and 2. 1 and 2, take from 1.
Highly obliged. Obliged.
I am taking a short break.
I think currently,
May please, your lordship.
Your lordship, we have the petitioner is behind the bars since last 32 days.
here
your
there is no.
Hmm?
Here there is no. No, immediately after this.
Heard Mr.
I.H. lordship.
I.H.
Laskar.
Laskar, learned counsel for the petitioner. Also heard Mr. R.J. Burwa, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed for case diary on 24th,
Can it be fixed on 23rd, your lordship, otherwise 24th?
on 23rd October.
Highly obliged.
Item 18.
May it please your lordship. Lordship, this is a 483 bail application, lordship. Here the woman in jail with 4 years baby, lordship, with her lordship. FIR that is on page 14.
What is the offense?
Lordship, it's an 21B, lordship. The police is actually searching her husband, lordship. Her husband abscond, lordship. Now police picked up her lordship. That FIR, lordship, will find on page 14. The specific note in the FIR is there, lordship. In the lordship, third paragraph from the bottom, note is there, head note is there, lordship.
Page?
Page 14, lordship. Due to night time, Mamoni Parveen, and she has a baby about 4 years and has a paralyzed woman at their residence. Therefore, after consulting with the respected OC Mukalmoa and Honorable SP Nolbari, kept under care of VDPS 1, Dolsal and responsible person of the village and instructed her to appear before the IO at 9 AM. It is pertinent to mention here the below noted apprehended
What is the
woman
offense?
21B lordship.
What was the recovery?
Recovery shown lordship as per lordship rejection order is a 1.43 gram of heroin lordship. That
1.43.
43 gram, that is observed in lordship page 24. 1.43 gram lordship. Page 24 lordship.
From where the recovery was made?
Recovery from the house lordship, but in the FIR said her husband was absconder lordship. That's why lordship I'm reading the FIR last portion.
Yes.
It is pertinent to mention that below noted apprehended woman and her husband deal in the illegal drugs and psychotropic substance since long. But against wife lordship, no previous track record is there. Therefore, request you to register a case necessary action against the apprehended woman and absconded husband as per provision of law. Actually, husband, police was searching the husband. They could not get husband. So picked up this lady lordship with a 4 years baby. And now they are in detention for 33 days. Lordship had rejection order that is on.
Detention period is too long. 33 days for 1 point.
So without content number of 2.28, my lord. That is also I am submitting from the case diary value. Yes, my lord.
Case diary is there. Okay.
That is, my lord, it is recovered from her house, my lord. Witnesses said, my lord, that her husband is basically, my lord, he is a peddler, my lord.
Okay. What is the recovery?
Heroin, my lord.
2 point?
2.28, my lord, without container.
Okay.
So as per the seizure is 20 gram, my lord, heroin with container, and 2.28 without container. It will come to a small quantity.
Heard Mr. B. Chaudhary, learned counsel.
Pending for the FSL report, my lord, so my submission is ready.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. R.J. Barwa, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Maiman Parveen, who has been detained behind the bars since 11/9/2024. For last how many days?
33 days lordship.
Within bracket, for last 33 days in connection with Mokalmoa PS case number 272/2024
Now lordship.
under section 21B of the NDPS Act, 1985. The gist of accusation in this case is that on 11/9/2024, one who lost the affair?
That is lost by lordship. Tridip Kumar Bora, IC, Dolshal, OP.
One Tridip Kumar Bora lodged an affair before the officer in charge of Mokalmoa Police Station, inter alia, alleging that on receipt of an information through reliable sources regarding illicit trade of narcotic drugs in the house of one Bilal Hussain, a search operation was conducted in the house of Bilal Hussain, and heroin of weighing about 20 grams within bracket with containers, bracket close, was recovered from there. However, said Bilal Hussain could not be apprehended as he absconded, and the present petitioner, who is the wife of the Bilal Hussain, was apprehended along with a baby of 4 years old. Stop. learned counsel for the petitioner has submitted that the petitioner is innocent and not involved in the offense alleged in the FIR. He submits the learned counsel for the petitioner also submits that from their reading of the FIR, it would reveal that the allegations in the FIR is against the husband of the petitioner. And as he absconded, the police apprehended the present petitioner. He has also submitted that the quantity of contraband seized in this case is 2.28 grams, which is a small quantity. However, the petitioner has been detained behind the bars for last 33 days. So, on the other hand, learned additional public prosecutor has objected to the prayer for grant of bail to the present petitioner on the ground that the investigation is still pending the receipt of FSL report. Any
Recovered from the house of the accused.
and the contraband has been recovered from the house of the accused person. Hence, there are implicating material against the present accused person in the case diary. Stop. I have considered the submissions made by learned counsel for both the sides and perused the materials available on record, including the case diary of Mokalmo appeals case number 272/2024. It appears that the allegation in the FIR was mainly against the husband of the present petitioner, though the petitioner also resides in the same house from where the recovery has been made. Moreover, the recovery is only of 2.28 grams of heroin, which is a small quantity of heroin. Stop. It also appears that the petitioner has already been detained behind the bars for last 33 days. Stop. Considering the quantity of quantity of contraband involved in this case, as well as period of detention already undergone by the petitioner, this court is of considered opinion that further custodial detention of the present petitioner would not be necessary for fair completion of the investigation of the case. Hence, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned special judge. Where?
Nolbari Lodge.
Learned special judge Nolbari. With following conditions. Condition number 1 and 2.
Highly obliged.
Send back the case diary.
Highly obliged.
Daily leaks,
Item 19 and 20.
May I please proceed?
Duta Bajatman.
This application was already rejected by this matter page number 21.
But the Honorable Court has released the case on 3/4/2024 by order dated 3/4/24.
Where is the order?
3/4/24.
No, it was earlier rejected by the
Mr. Honorable Justice Arfukon, and on
an earlier application for bail was rejected.
rejected by that court.
Then in this application, an interim prayer was made,
Yes,
which was also rejected.
yes.
And what happened on 3/4?
3-4, the Honorable Mr. Justice Fukan has released the case lawsuit. By noting that not by me.
Where it is mentioned?
3-4-24.
No, it is not mentioned.
But it has been,
Only interim bail was not extended. Four.
in the case of 3-1-4.
Four.
Sorry, Lord, maybe 4-4.
4. Yes. No, yes, Mr. Borwa. It was earlier rejected by a coordinate bench. That bench has passed an order that he is not inclined to take up the matter. Then we can take it up. Now, what has happened now?
Lordship, first of all,
Why your earlier prayer was rejected?
my earlier prayer was rejected after praising the CD. There found some incriminating material against us. We are the elder brother and nephew of the main culprit, Abdul Mukut Chaudhry. And thereafter, he has been arrested. The fact of the case is that one lady, Bangladeshi lady, Rina Akhtar, came to the Hozai, that is the house of the petitioner, along with Abdul Mukut Chaudhry, who were in Dubai. And the lady claimed that the Abdul Mukut Chaudhry, Abdul Batin Chaudhry got married with this Rina Akhtar, and now he is not maintaining her. And claiming her rights, she came to the Hozai and she make hue and cry. Then what happened? One Mr. Abdul Mukit Chaudhry filed an FIR before the Murazar police station. That FIR was not at all entertained. Then on the basis of our information, police, what happened, Lordship? Police made an inquiry, they filed an FIR against us and along with the Rina Akhtar after several many sections, along with 120B, 419, 468, 471, and 14 of Foreigners Act. Allegation was that we have made some manufactured some document like voter ID, PAN card, like that document, so that we can claim the Bangladeshi woman Rina Akhtar be an Indian national. That was the main allegation. That has been registered as a Murazar PS case number 11. After that, what happened, Lordship? Rina Akhtar filed an FIR alleging the same incident. That FIR was registered as Murazar PS 12 after 4 days. Then, Lordship, what happened? We have been implicated in this case. So
This is 11 or 12?
This is 729-24 is 11 and 314-23 is 12.
Okay. So main allegation is that you made false document.
Yes, Lordship. Then our submission is that, Lordship, the husband is Abdul Batin Chaudhry may manipulate or may manufacture some document. He has been arrested later on. So, Lordship, the CD, the first CD was returned. It was ordered that the statement of Abdul Batin Chaudhry, who was the husband of the Rina Akhtar, may be called for. I think the statement of Abdul Batin Chaudhry is there. If your Lordship peruse the CD or the statement made by the Abdul Batin Chaudhry, that will say whether we have been implicated or we were involved in this case or not. Because I'm elder sister of the Abdul Batin Chaudhry and nephew of Abdul Batin Chaudhry.
Abdul Ahad is
a nephew of the Abdul Batin Chaudhry.
Son of petitioner number 1.
Son of, yes, Manwara Begum.
Manwara and Abdul are mother and son.
Yes, Lordship. And Abdul is an advocate also, Lordship. At that point of time, he was not there, he was in Guwahati itself. And what happened, Lordship, when the
Where is the FIR?
FIR in the case, Lordship, taking which case, Lordship? 314,
31, no, 729.
729, FIR at page number 12, Lordship. Eleven, Lordship.
Who is Hajira Begum?
Lordship, Hazira Begum, one of the relative of Abdul Batin Chaudhary, Lordship.
And who is that Bangladeshi lady? In
Rina Akhtar.
Rina Akhtar.
She has been allowed on bail, Lordship. She was arrested. She has been allowed on bail. The Abdul Batin Chaudhary, the main accused, has been allowed on bail.
Abdul Batin Chaudhary has also been enlarged on.
Lordship.
Okay. Yes, Mr.
With a successive bail application, madam. We have to satisfy this honorable court, what happened after rejection of the first one?
Why your first prayer was rejected?
My first prayer was rejected. After perusing the CD, there was incriminating material against us. Then thereafter, the Abdul Batin Chaudhary, the main accused, has been arrested because on that case, he was
So
also.
you want to say that after recording of statement of Abdul Batin Chaudhary, his
Yes,
statement may exonerate you.
definitely.
Yes, Mr. Burwa. No, what Abdul Batin Chaudhary says. How they are implicated? No, what they have stated.
Person has not specifically implicated, my lord.
Who has implicated?
That the lady, my lord, who is the my lord, Bangladeshi lady.
What she has stated?
That is my lord, Abdul Ahad, my lord. Who introduced himself as a lawyer of Guwahati High Court, my lord. They made Aadhaar card, PAN card, birth certificate, school certificate, bank account, as well as the voter ID in the name of Hajira Begum, my lord, that she has changed her name to Hajira Begum. And my lord, as far as this Modwara is concerned, my lord, he stayed in her house illegally.
So,
In this case,
There are
Lord,
materials, my lord, I can do.
in this
against Manwara, materials are not there.
Owing her, my lord, she is a Bangladeshi national. She is also same.
this
But that is not the offense
No,
in
not
this
the
case.
not difference. And in case of Abdul Ahad, on this period, Lordship, he was in Guwahati, and when their FIR was not registered by the police, he went Hosai. He had some altercation with the police, and that is the main thing. And that is why police is what happened, Lordship, for 10, that is from 6/3/2014, and this is 15/10, that's for 7 months, they have not sent a CD. After reminder, they have sent CD last date, Lordship. And on 17/9/2024, show cause was also been issued against the IO, Lordship. That is the main case. And Lordship, if we are involved, then we will face the trial, Lordship. And we are ready to cooperate with the investigation. In case of there is nothing serious offense except the forgery, Lordship. If we have done that, has already not done, Lordship. And whatever have been done, that is by the Abdul Batin Chaudhary, that the husband of the victim, Lordship.
Who have implicated? Where is your previous bail order, which was rejected?
It is page number 21, Lordship. Operative part at 23.
Now, Mr. Borua, who has implicated him? The Bangladeshi lady.
The lady, my lord,
Whoa.
signature was forged by forging the signature, my lord, PAN card, Aadhaar card, my lord, birth certificate, everything has been, my lord, fulfilled.
What is her statement? And Abdul Batin Chaudhry's statement?
Our humble submission is that Lordship kindly consider the statement of Abdul Batin Chaudhry because he is the main man behind all the sin, Lordship.
No, but Abdul Batin Chaudhry has revealed the name of the person who helped him in making forged documents.
The investigation is still, my lord. We have to, my lord, take in the political action, my lord. We don't know both the person, well. Because Abdul Qadir Chaudhry is the husband, my lord.
Hmm. He brought
He brought this lady, my lord, from my lord, Saudi Arabia or something, my lord, to India, my lord. Although she is a citizen of Bangladesh. Bangladesh.
and he is saying that I engaged so and so.
We had no knowledge about these things, Lordship, prior to the incident. Because he is the
Heard Mr. What is your name?
AK Sharma.
Heard Mr. A.K. Sharma, learned counsel for the petitioner. Also heard Mr. R.J. Borua, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973 has been filed by the petitioners Manwara Begum and number 2 Abdul Ahad, who are apprehending their arrest in connection with Morajhar PS case number
11 of
11 of 2024 under section 120B/419/468/417 of the
471.
471 of the Indian Penal Code, read with section 14 of the Foreigners Act, 9. Learned counsel for the petitioner has before that, the petitioner has approached this court for the second time. Stop. Their earlier anticipatory bail application
342-2034.
was rejected by order dated 26/2/2024, passed in anticipatory bail application number 342/2024 on the ground that at that stage of the investigation, sufficient incriminating materials were there in the case diary. Learned counsel for the petitioner has submitted that after rejection of the earlier bail application, the main accused of this case, namely
Abdul Batin Chaudhary.
Abdul Batin Chaudhary, was arrested and his statement was recorded by the investigating officer. Learned counsel for the petitioner has also submitted that from statement of the accused Abdul Batin Chaudhary, which was recorded during the course of investigation, it would be revealed whether or not the present petitioners are involved in any manner in the offense alleged in this case or not. Learned counsel for the petitioners has also submitted that the petitioners have been falsely implicated in this case. They are in no manner involved in the offense alleged in the FIR. He has submitted that the main accused of this case, namely Abdul Batin Chaudhary, while he was working in Saudi Arabia, got acquainted to a
Rina,
Bangladeshi woman, namely Rina Akhtar. Stop. He fell in love with the said lady and later on married her and brought her to India. Illegally. And thereafter, he engaged some persons for making fake documents in the name of his wife. Stop. Learned. Stop. On the other hand, learned additional public prosecutor has submitted that the bail application of the present petitioners was earlier rejected by this court on the ground that sufficient incriminating materials was available and no material change has been there in the said position, and therefore the second anticipatory bail application is not maintainable. Learned additional public prosecutor has produced the case diary of Murajar PS case number 11/2024 and has submitted that one of the co-accused, namely Rina Akhtar, has implicated the present petitioners in the offense involved in the offense alleged in the FIR, and hence he has opposed the grant of bail to the present petitioner. Counsel for petitioner at a line Humay Dibaru. For the counsel for the petitioner has also submitted that in the meanwhile, both Abdul Matin Majumdar as well Abdul Matin Chaudhary
Abdul Batin Chaudhary.
Abdul Batin Chaudhary as well as Rina Akhtar have already been granted bail. And both have already been granted bail. Stop. Now, I have considered the submissions made by learned counsel for both the sides and perused the materials available on record. Though on earlier occasion, the anticipatory bail application of the present petitioner was rejected by this court on the ground that incriminating materials was there against the present petitioners, however, at that point of time, the statement of main accused, namely Abdul Batin Chaudhry, was not available in the case diary, and it was also not available before the court. Now, on perusal of the statement of Abdul Batin Chaudhry, it appears that it is he who contacted one Abdul Hasib of Nilbagan Buribai, who made the forged document, who made the alleged forged documents. It is also the materials in the case diary also reveals that the said Abdul Batin Chaudhry had entered into a deal for making the forged document by paying rupees 1 lakh, out of which 80,000 has already been paid by him. Stop. This new revelation during investigation shows that the present petitioners are not involved and does not appear to be, no, in a line to now. The aforesaid revelation during investigation after recording the statement of Abdul Batin Chaudhry tilt the balance in favor of the present petitioner while considering their second bail application. Stop. The fact that the main accused persons, both Abdul Batin Chaudhry as well as
Rina
Akhtar have already been granted bail also goes in favor of the present petitioners. Considering the entire aspect of this case, this court is of considered opinion that custodial detention of the present petitioner may not be necessary if they cooperate in the investigation. In the investigation of the case. Stop. In view of above, this anticipatory bail application is disposed of with a direction to the present petitioners to appear before the investigating officer of Murajhar PS case number 11/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Murajhar PS case number 11/2024, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2, two conditions. With above observation, this anticipatory bail application is disposed of. Send back the case. What is this second one?
This is the FIR filed by the redactor also.
Against?
Different case, my lord, fever, allegation is the fever assumption, my lord. In this case, my lord, the medical report would be necessary. But the absolute case there may be possible.
Lordship, it's an anticipated bail and it has been filed prior to 10 months. And Lordship, if there is any implication, then it is 323, 354, 307 and 379. And if there's some allegation or
Case diary is there.
If there is. If there is, my lord, her 162% has been recorded, my lord, she has implicated, my lord.
What she has stated. What is the injury she has suffered?
It's a long statement, my lord.
P07 is also there.
307 Lordship.
Where is the FIR?
FIR is page 14.
The accused persons are same.
Same Lordship.
But
Her husband, my lord. My lord, their allegation, no, my lord, they have all assaulted her, my lord. So, my lord, I get to call for the, my lord, injury report, my lord, we retain the case there, my lord. So the injury report will be necessary.
So kindly, if your Lordship consider the case diary, because it's a case of 2023, and police is doing the investigation in this space, that they cannot procure, that they cannot supply the injury report to this court, and they have sent a CD without the injury report because the assault is the main part in this FIR.
and this is a very old bail petition.
Yes, Lordship. Very
Filed
old
in the month of February.
February, Lordship.
Then, my lord, let it come on, my lord, Monday, my lord, and verify whether injury report is collectible.
Lordship,
Till Monday, my lord.
if there was any injury, that would have in the CD.
Oh, then let us concede to PP's request. Let it come on Monday.
Lordship, on that case, this order will be affected because we have only 7 days. So if we take time, then Lordship, we are accused in this case also. And one more thing is, Lordship, in the case of TT and
I will only obtain my instruction whether, my lord, the medical report is collected or not. If it is collected, my lord, then I will obtain it, my lord, to also go.
No, no. What is the allegation? What injury she has suffered?
By the accused person.
No, assaulted. What injury she has suffered? What is the statement? Where she has suffered injury? In her statement, she must have stated that my leg is broken and or mere statement that I have been assaulted.
Mayor statement, my lord, then all this person.
Then-
My lord, and Madhwara and Ibu, my lord, they hold her hand and legs, my lord. When the other accused person were assaulted.
it's an unbelievable story, Lordship. She has made those statements to defend her. Because she knew that
Not the unbelievable, it's believable, my lord.
Okay.
164
In earlier case, instead of 7 days, make it 15 days. And this we are fixing on Monday.
Lordship, yeah, in this aspect, I would like to have the case of TT Anthony. In the TT Anthony, this case
No,
judgment,
but this is a different case.
but on the same circumstance, same incident,
Mhm.
Lordship.
That is regarding forgery. This is regarding assault.
But in the same incident, what police would have done in the case of Murazar PS11, they would have add these sections and they would have investigated in the Murazar PS11.
No.
Not, they need not to
Heard-
register this case, Lordship.
Heard
Because-
Mr. A.K. Sharma, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor, who submits that though the case diary is available, however, injury report is not available in the case diary. And considering the nature of allegations made in the FIR, injury reports would be necessary. On the other hand, learned counsel for the petitioner has submitted that this bail application is pending since February this year, and the police is unable to collect the injury report, which is a deliberate attempt, which appears to be deliberate attempt on their part. Stop. Learned additional public prosecutor submits that he would telephonically inquire about injury report and the nature of injury sustained by the victim and let this court know on the next date fix. The prayer is allowed. Let this case be listed again on 21/10/2020.
Lordship, that may be the last option, the last date or last chance, as because Lordship, we are connected in this case. If they
No,
will
that
take-
you may submit, you may make submission
on that date.
on that. No, it is last. The tone and tenor of the order would show that no indulgence will be granted. Because additional public prosecutor has himself taken on that he will inform the court. It is not IO. So he will take information.
Deeply obliged.
My plea, Lord. My lord, in this case, FIR at page 11, my lord. Here, my lord, in the FIR lost by one SI, my lord. Wherein
What is the offense?
offense, my lord, alleged that NDPS under section 21B. Here, my lord, the two persons arrested from whom the materials recovered. And during the,
What is the material?
my lord, heroin, my lord,
How much?
suspected heroin, total 22 gram. Larger than small and below greater. And big amount is 250 gram. Here, my lord, nothing has been recovered from the present petitioners. It is, my lord, the page
From whose possession?
who were already arrested, my lord, and subsequently the house of the petitioner searched and his vehicle also recovered, seized, and nothing has been recovered from his house and from his vehicle.
No, just a minute. From whose possession the
One Shahidul Islam,
During interrogation, he said that these two persons
my
were
lord, page
involved in peddling.
11 bottom, my lord.
read?
Yes, my lord. I, along with police party, used government vehicle Bolero bearing number such and such, driven by Homeguard S. Ali, along with investigation key towards Golia village. Accordingly, at about 7:50 p.m., we arrived at Golia near Golia Tolla Plaza and so as indicate by the reliable source, the person, namely Shahidul Islam, son of such and such, P.S. Hauli district, Borpeta, Assam, was coming from Hauli side towards Bhavanipur by e-rickshaw. After that intercepted the e-rickshaw having no number plate and apprehended the accused and asked two local independent witnesses, namely such and such, Hemanto Kumar Das, number 2, Kamalnath of village Purana Golia, P.S. Patasarkusi district, district Bozali, Assam, are requested them to witnesses.
What is your name?
My name is Malad Naimuddin and Zahirul Islam. In next page, Malad. page 12, my lord, in second paragraph. My name is inserted
CD
here.
is there.
It is there, Lordship, now accessible call for it.
No, but assuming that FSL is positive. If FSL is negative, it will help the accused. If it is positive, it may not help. So we will assume that FSL report is positive. Then make your submission.
Yes, Lordship, the police Lordship visited their place, Lordship, they cleared away, Lordship, seeing the police. Lordship. If they have no involvement. Because, Lordship,
Seeing police, many people flee away. But this is a, the only material appears to be the statement of co-accused. Apart from that, is there any material?
investigation is say because police will need some witnesses Lordship, about their involvement. Because as it is in the investigation stage. Lordship.
27.
My lord, it is recovered nothing from the accused, my lord, and the vehicle says that is.
Let them appear.
My lord,
They are Lordship, and if
No,
they-
FSL,
it's similar, because.
no, we will not keep this pending.
Was Lordship, the person who expected Lordship, the gist of the case was that the one person made Heroin trial Lordship always. When he was asked, he told that he used to.
No,
take-
they will appear before you. They will appear before investigating officer. If Mr. What is your name?
K.U. Ahmed.
A.U. Ahmed, learned counsel for the petitioner. Also heard Miss A. Begum, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioners Jahirul Islam Khan alias Jahirul Islam and Naimuddin, who are apprehending their arrest in connection with Patasar Kusi PS case number 149/2024. The gist of accusation in this case is that 1/27/2024, one Vikas Jyoti Deka had lodged an FIR before the officer in charge of Patasar Kusi PS case, Patasar Kusi police station, inter alia, alleging that on receipt of an information through reliable sources, a search operation was conducted near Galia Toll Plaza, and one Shahidul Islam was apprehended therefrom. On search of the said person, 22 grams of suspected heroin was recovered from possession of the said Shahidul Islam. It is also stated in the FIR that during interrogation, the apprehended accused stated that the present petitioners were also involved in this, in the offense alleged in the FIR. Stop. Learned counsel for the petitioner has submitted that the petitioners have been falsely implicated in the FIR and nothing was recovered from their possession. It is also submitted that Tufan Singh, what is the citation?
My lord,
You will not get bail if you don't.
my lord,
Bring the citation.
My lord, at present I am not.
Because only that case will help you.
Yes, my lord. One case is there, my lord, that is Ram Singh, my lord. My lord, Tufan Singh versus State of Tamil Nadu, 2021.
Learned counsel for the petitioner has submitted that the statement of a co-accused in NDPS cases regarding recovery of in NDPS cases is not admissible as held by the apex court in the case of Tufan Singh versus State of Tamil Nadu, reported
2021,
in
4 SCC,
2021
one.
4 SCC,
page 1.
page 1. Stop. It is also submitted by learned counsel for the petitioner that the petitioners are ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioners on the ground that they have been implicated by the co-accused from whose possession the contraband was recovered. It is also submitted by learned additional public prosecutor that as the investigation is in early stage, there is a possibility of recovery of evidence, collection of evidence against the present petitioners. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through materials on record, including the case diary of Patasar CPS case number
149.
149/2024. So on perusal of the materials on record, it appears that nothing has been recovered from the possession of the present petitioners, and the accused from whose possession the contraband has been recovered has already been arrested. Stop. It also appears that the only materials against the present petitioner in the case diary is the statement of the co-accused, which in view of the judgment of the apex court in the case of Tufan Singh versus State of Tamil Nadu within bracket Supra is not admissible against the present petitioners. Stop. In view of above, this anticipatory bail application is disposed of with a direction to both the petitioners to appear before the investigating officer of Patasar CPS case number 149/2024 within a period of
7 days, maybe?
7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with the Patasar CPS case number 149/2024, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Send back the case diary with this anticipatory bail application is accordingly disposed.
Obliged.
22. We'll fix for case diary.
Only a short prayer, my lord. The petitioner is a student, college going student. Kindly protect till case there is come.
At 2. At 2 will.
Obliged. 19, 366, 361. The main accused was already arrested, my lord. FIR is page number 17. Yes, yes,
Let CD come. Now, how you are involved?
I got involved, my lord. During the interrogation, the arrested accused has informed the police that he gave some money to me. And in this regard, the police also interrogated my family members.
Yes.
Only, my lord, I am police going to then, my lord. And the police arrested, my lord, my entire career will be at stake, my lord.
We fixed it, madam, from 24th, madam.
He's a student of higher
I-
secondary only.
No, I've already enclosed, my lord, his certificates and others, my lord. Presently, he's at ITI Jorhat, my lord. He's taking training. My lord. Only 19 years student, my lord.
The case diary come, madam. Cannot produce the case diary on that day, madam.
No, but you have failed to produce case diary today.
This is the fact that. The vacation put, my lord. You have already, madam, issued declaration, madam, kept up.
Why I has not sent the case diary? 410. 410 and today is 1510, 11 days.
Twenty-first, madam.
Twenty-first.
At least I'm kindly protecting, my lord, till then.
Only 4 days. Let the case diary come. Heard Mr.
C. Chakraborty, my lord.
S.
C. Chakraborty.
C. Chakravarti, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed on 21/10/2024 for case diary.
Not really, Your Honor. Not bail petition, Your Lordship, regular bail petition. FIR at page 8, Your Lordship. Section is 21B, Your Lordship. This is not commercial quantity. In between, Your Lordship. Mandatory period is
What? When were you arrested?
arrested on 28/8, Your Lordship. As on date 48 days in custody, Your Lordship. 29/8/24. 48 days. in
What is
custody.
the quantity of contraband?
My lord, at page 9, Your Lordship.
No, what is the quantity? What?
120, weighing 120 gram, Your Lordship.
Of?
Milligram. Yeah, without cover. Holding report.
What has been seized?
Suspected to be heroin, Your Lord.
120 milligram heroin,
My-
120. Case diary would be required. Heard. Mr.
125, my lord.
N. Alam,
Era.
A. Rahman, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the same. The list this matter on 25/10/2024 for case diary.
Oblige, Your Lord.
May I please your lordship, 483 application, my lord. Offence is under section 21B of the NDPS Act, my lord. My lord, today is the 25 days, my lord, behind the bar, my lord. My lord, from FIR is at page number 11. My lord, may come to the page number 13, my lord. Type copy, my lord. My lord, from the FIR, it is revealed that, my lord, it is not being recovered from the position of the petitioner, my lord. This,
What has been recovered?
my lord, heroin, my lord, 10.3 gram, my lord, without container. From a lady, my lord, from the body of the lady.
How you are involved?
My lord, I am the driver of the car, my lord.
Yes, Mr. Borra. Case diary will be. Heard Mr.
A guy on behalf of S. Munir.
A. Gayan submitting on behalf of Mr. S. Munir. Considering the allegations made in the FIR, the perusal of case diary would be necessary. Hence,
Along
call-
with the medical report, my lord. He is being subsequently admitted on 8/10, my lord.
along with the medical report of the petitioner, as he is reported to be admitted in hospital. Let this matter be listed again on
My lord,
28,
short date, my lord, 25, my lord.
25/10.
March of last.
May it please, your lordship, this matter pertains to, my lord, selection and appointment to the post of junior assistant, my lord, in the Airport Authority of India, my lord, in the Northeast region, my lord. My lord, in this matter,
Selection, appointment to the post of
junior assistant fire services, in the, my lord, airport, my lord, floated by the Airport Authority of India, my lord. So, my lord, this matter, what had happened was, my lord will kindly come to, my lord, the page 5. The Airport Authority had floated a advertisement number 0123 DRNER dated 30/12/23, which is at page 5, my lord. Annexure 19 is the annexure, is the main annexure.
page number.
Page number 19 is the annexure. It's that is the advertisement, my lord. Page number 19.
Okay.
So this is the big advertisement, my lord. And accordingly, my lord, the petitioner had applied for the same, my lord. And after applying for the same, his admit card was issued to him, my lord, bearing roll number so and so, which is at page 37, my lord. The roll number is at
Okay.
page 30.
Thereafter,
Thereafter, what happened, my lord? The petitioner appeared for the online test, my lord, which is the computer-based test held on 21/4/2024 at Imphal in respect of the said junior assistant post and successfully cleared the same, my lord. And my lord, after this, my lord, pursuant to that, my lord, the physical measurement, physical fitness test and driving test and physical endurance test was, my lord, was fixed, my lord, on 21/8/24 at the SM Rifles campus at Agartala, my lord. That is marked as, my lord, at page 40, my lord. Page 40 is the annexure, relevant annexure. Thereafter, my lord, what happened was, after the petitioner, my lord, he went there, my lord, for the physical measurement fitness test, my lord. What had happened was, to the utter shock and surprise, my lord, orally, my lord, he was informed by the Airport Authority of India, my lord, that he suffers from bow leg in medical examination, my lord, and he basically he will be disqualified. Therefore, my lord, orally he was told that he was disqualified. Immediately, what happened, my lord? The petitioner, being a diligent citizen, my lord, of the my lord, diligent citizen and candidate, my lord. He's a diligent citizen. He immediately went for a re-verification and re-examination, my lord. He went to the Jawaharlal Nehru Institute of Medicine Sciences, which is at Porampot, Manipur. My lord, kindly see at page 46.
you were orally informed.
Initially,
regarding-
yes, sir. Initially, orally. Initially, he was orally informed that, my lord, nothing written was given. I'll come thereafter. The main imprimatur order is subsequent.
So they first tell him that you have.
There is no system of orally
No,
informed.
no.
Exactly, my lord.
Also,
I will come to that.
There is no
My lord,
basis to it.
I have not challenged that, but I will, I'm saying, I will not, I have not challenged the first, the bow thing, my lord. I have challenged the eyesight, the current one, which is at page, my lord, which is the email.
Thereafter, what happened?
Thereafter, my lord, what happened? The petitioner had gone to the orthopedic department of the, my lord, of the Jawaharlal Nehru Institute of Medical Sciences.
And it was
Kindly,
found that you were not.
kindly come to page 46, my lord. Kindly come to page 46, my lord. Kindly come to page 46. 46, I have made the relevant type copy also, my lord. Annexure 5, outpatient record, my lord. The petitioner Malongjam, orthopedics, my lord. Knock knee, nil, my lord. Second is bow leg, nil. And thereafter, my lord, no spinal infirmity, my lord. So he's, in terms of, he's physically fit in terms of the medical, my lord, regarding orthopedics. This is just to indicate, my lord, because I have to bring this to your notice, my lord. Thereafter, my lord, what happened was, thereafter, after getting this report from the Jawaharlal Nehru Institute of Medical Sciences, Parampot, the petitioner gives a representation accordingly, my lord, to the to the Airport Authority of India to consider his case, my lord, which is at page 48, my lord. Copy of the representation dated 11/9/2024, my lord. If your lordship sees page annexure 6, my lord. Page 48. That is the representation after the bow thing, which they gave orally, my lord. Now, my lord, will see. Now what happens is, in the meantime, what had happened, my lord, the concerned petitioner had filed a writ petition bearing 682 of 24 before the Manipur High Court, my lord, regarding this ground, bow leg. But that was, my lord, subsequently withdrawn. That was withdrawn there. That was withdrawn. Because my lord, let me complete. He will get his chance, my lord. He's interrupting me, my lord. So at that point of time, he had approached the Manipur High Court, my lord. I have brought that everything on record. I have brought everything on record. So he had filed 682 based on the bow leg. So since when they didn't get anything written, so that order also have annexed, my lord, which is at page 49. Kindly come to 49. That writ petition was, my lord, withdrawn by us, my lord. That since that bow leg thing did not come in the written form, so that is given at page 27/9 order, my lord. I heard so and so. Petition 6 leave to withdraw the present petition with liberty to file appropriate petition. So till then, my lord, we were anticipating that, my lord, because we have given a representation, we were anticipating that our representation will be considered because no reply had come. Now, my lord, thereafter, what had happened was that however, at the point, then later on, my lord, during the pendants, my lord, we received a reply, now email, my lord. This is the crucial. This is the, my lord, page 50. During the pendency only, my lord, we received an email from the respondent in respect of the aforementioned representation. That 11/9 was submitted, my lord. Now here they take a total complete U-turn, my lord. My lord, here they, if your lordship comes to page 50, Mr. Lordship got it? Annexure 8.
Yes.
Here now, my lord, after we give the representation and after we have withdrawn the writ petition in the Manipur High Court, we get a reply from, my lord, an email from the Airport Authority of India. Now they have taken a complete U-turn. Initially, they told us that it is orally bow leg. Now they say that with reference to your trailing mail, my lord, if I may, it is stated that as per reports, the Government Medical Authority Agartala, comprising different expert doctors, your height and eyesight is not as per the requirement, as per the advertisement notified by the Airport Authority, my lord. Doctor is the subject matter expert and the medical examination has been carried out in the hospital using equipment of the hospital. Medical authorities under control environment. There is decision on your disqualification for the further stages of the selection process as per the reports of the medical authority, my lord. That is the impugned letter, my lord. They have not given any proper notice also they have not given. They have just given me an email. So this is my impugned, my lord, email which I'm praying for setting aside. Now, interestingly, my lord, kindly I would like to draw your lordship's attention to the advertisement, my lord. Lordship will kindly come to the advertisement at page 23, my lord. Page 23, my lord.
Yes.
Has your lordship got it? Lordship in page 23, your lordship marks it, height, my lord. Lordship will mark it 167 centimeters. That is for everyone, my lord. Kindly see, my lord.
Yes.
167 centimeter. And my lord, kindly see 167.
67 or.
And my lord, eyesight. Kindly see above physical fitness, eyesight. First eyesight, my lord. Eyesight is distance 6 by 6, my lord. Each eye, my lord.
Yes.
Then near vision is N5, each without glasses. Then color vision should be normal, my lord. Thereafter, this is crucial for the case, my lord. Thereafter, night blindness is absent. It has to be absent. Therefore, then my lord, field vision, each eye should have full field eye. And my lord, retractive error, no retractive error is acceptable. That is the, my lord, fundamental requirement. That is the eyesight. That's the first thing. Second, my lord, will come to height, because these two things they're saying that requirement is not met. Second is not less than 167 centimeter. And my lord will now again come just right below that, my lord. Below that two hashtags are there. Relaxation of 3 centimeters in height, my lord. Since my candidate, my lord, is from Manipur, my lord, it's a hill state, my lord. It's a hill state. So therefore, relaxation of 3 centimeters in height for both male and female candidates, and chest measurements only for male candidates, and proportionate relaxation in weight will be allowed to hilly area candidates. On, my lord, this is crucial, on production of bona fide certificates, my lord. We'll kindly note that part. And this is at page 23.
Yes.
So on production of bona fide certificate, this 3 centimeter weight height relaxation we'll get because of we are from Manipur, my lord, because we are from a hill state, my lord, only on production of them. Now, my lord, will come to the next thing which I would like to show. Now I would like to come to the page 51, my lord. After getting this reply from the at page 50, my lord, where they said that eyesight is bad and you're not as per requirement. This is their own advertisement, my lord, which I have just now showed in page 23. This is their own rules they have made. Now, my lord, after in 50, they said that eyesight and this thing, my lord, eyesight and height is not as per the rules. Now, my lordship will kindly come to page 51. So as soon as we got this mail, my lord, immediately the candidate, because he's diligent, my lord, he immediately went on 26/9, because on 26/9 he got this email. On 26/9 itself, he went to the Jawaharlal Nehru Institute of Medical Sciences, my lord, where he has, my lord, registered himself. And there, my lord, the kindly check this, my lord, medical checkup, page 51. Advice is VN, my lord. VN is 6/6, my lord, as per the requirement. Next is, my lord, refractive BE accepts plano 6/6. That means it's absolutely fine. Next is, my lord, near VN, normal, my lord.
Okay, your eyesight and height is within.
Within this thing. I want to show one more thing. Color VN, normal. Color VN again is normal. Night blindness, absent, my lord. And this has been endorsed by the Jawaharlal Nehru Institute of Medical Sciences. And right below, next to that, my lord, we'll come to page 52. That is the regarding my height. I am, my lord, I have been registered now here. They check my height. It is 164.5, my lord. So as per the, my lord, again, my lord, it's my height is 164.5 centimeters. Kindly come back to the, my lord, advertisement, my lord, at page 23. Kindly come to page 23, my lord.
Relaxation of
Relaxation of 3 centimeters in height, my lord, that is 167 is the actual. So 167 minus 3 centimeter will be, my lord, 164. I am 164.5, my lord. I'm 0.5 ahead, my lord. I am fit to be taken in, my lord. Now, my lord, will come to the crucial part, my lord, whether I have submitted the bona fide certificate or not. That I will show on the next occasion, my lord. Kindly come to the next this thing, my lord. Next, at page 55, my lord, annexure 10. Annexure 10 is the, my lord, is the bona fide certificate, my lord. This is the bona fide certificate, which is the crucial, my lord, which will play, because we have produced this, my lord, when the scrutiny took place, my lord. This is, my lord, to whom it may concern, and it is been issued on 29 April 24. It has been issued by the government of Manipur, Deputy Commissioner's Office, Imphal West District. This is to certify that Sri Longjam Vidyan Singh, so-and-so, is a permanent resident of so-and-so, post office in so-and-so, so-and-so. He belongs to the Maitai community of Manipur state and may be considered for relaxation in height and chest measurement for recruitment in paramilitary forces and other related services of the Union of India. So this, my lord, is crucial. Now kindly come to, my lord, I would like to just draw your attention again, my lord, to their advertisement, my lord, which they have made, which just a minute, I'll just is at page, just a minute. Yes, ma'am. Which is at page 34, my lord. Page 34. Kindly see page 34 of the advertisement. 10.33.
Page
34. Page 34, clause 10.32. Mr. Lordship, got it?
Yes.
Page 34, clause 10.32. I may be allowed to read it, my lord?
Yes.
During document verification, the candidate will have to produce original certificates along with the identity and one set of attested photocopies of all certificates. If the ID candidate is in doubt or he or she is not able to produce the requisite documents, or there is a mismatch of information in the documents, his candidature will be rejected. So my lord, here in this scrutiny time, my candidate has produced the document, my lord, before the concerned authority. Now, my lord, initially they came orally, they said that I have bow leg. That also I satisfied them that I am not, I have given my representation. Subsequently, I'll tell you, my lord, that again they give a when they came to know that we have withdrawn the first case regarding the bow in the Manipur High Court. They have then given us a mail that your eyesight and your height, every time they're trying to bulldoze me, my lord. They're trying to.
No, they have never communicated you that you have.
Exactly, they didn't communicate also. And the second one, my lord, they gave us the 26/9. They have given us an email. They should be giving us a proper notice, my lord. They have not given us that. And my lord, even after not giving that, we're gone to the thing, and after that again we have given a representation. That also now, my lord, yesterday when I filed this case, my lord, I have got a reply from them that we are asking for an independent, because our medical this thing also has been.
No,
my lord,
you have filed
another
representation.
Yes, no, one more. I want to just point out, my lord,
Where is that?
before my lord, I just want to show one more thing, my lord. I want to bring to your record. This particular case was filed also, my lord. Subsequent to that, my lord, one more case before the vacation was filed in Manipur. After this case, which I have annexed, one more case was filed in regarding the eyesight. What had happened was, my lord,
Why cases are filed in Manipur High Court as well as Guwahati High Court?
I will satisfy your lordship if your lordship allows me to. What had happened was, my lord, the client is from Manipur. So, my lord, what happened was, we thought that, I mean, the council there had filed it there after this thing, and the stay order was given by the Manipur High Court, my lord. The stay order was given by the Manipur High Court. But then, my lord, if your lordship comes again to the 10.36, my lord. Yes, sir, 10.35 of page 34 again, my lord, page 34. This is the order of the Manipur High Court, my lord, where stay was granted to us, my lord, until yesterday, because yesterday we have ourselves withdrawn it, my lord, because, my lord, there is a clause in the, my lord, there's a clause in the advertisement, which is very small written, my lord, that any litigation or anything legal, my lord, will come to 10.35, page 34. There it is given, any legal proceeding in respect of any matter of claim or dispute arising out of this advertisement and or application in response thereto can be considered only in Guwahati. So that we came to know, my lord, after we got the stay, and my lord, bona fidely, we have, my lord, also, my lord, I will like to show that we have got the withdrawal order also yesterday, my lord. Kindly see me. We have withdrawn it yesterday. We have taken the liberty from the court in Manipur, my lord, that we will file it here, my lord. We have also mentioned that in paragraph 13 of our writ petition that we have filed it, and that we are going to withdraw this particular, though we have got a stay, my lord. We could have not done that, but we have been, my lord, transparent, and we have yesterday, my lord, the order has been given to me, communicated to me today, my lord, that
this stay is in respect of that eyesight and height.
because we have prior satisfied, because that same case we have filed, the same case we have filed there. But then after getting the stay, we came to know that the 10.35, my lord, page 34, 10.35 of the advertisement, that says that litigation, should kindly come to page 34.
Okay.
Page 34 of the advertisement. Page 34 of the advertisement. 10.3.5. There it is said that any legal proceeding in respect of any matter of claim or dispute arising out of this advertisement, thereto can be instituted only in Guwahati and courts, tribunals, forums in Guwahati. So this we had inadvertently, mistakenly, we had not seen. So therefore, we had filed. But then it was, in fact, it should have been the airport authority who should have been the one who should have said that this matter should not be pressed there. But we, in fact, when after getting the stay also, we have yesterday, my lord, 14th yesterday, my lord, the council there, my lord, had appeared, my lord, and had appeared there, my lord, and has given this particular thing, my lord. So, and we have taken the liberty to file it here, my lord. So therefore, my lord, we have filed it here. And my lord, since I have made out a case, my lord, where I have shown, my lord, that till date, my lord,
have you informed the authorities that you have undergone?
Yes, my lord, because caveat, they have filed a caveat.
No,
my lord.
Have you filed a second representation?
Yes, my lord, it is here. It is absolutely here.
Where
my lord
is,
will kindly see. I will show you one.
Where is that?
1 minute. kindly check, my lord, page the last page, my lord, the last page. 56. Page 56, my lord. This is the representation given,
When have you filed?
my lord, we have given it to the regional executive director airport
When?
on 27/9, just the day after that. And my lord, we have also received, and interestingly, my lord, reply to this has been received by us yesterday after we have filed, because he has filed a caveat. He had filed a caveat.
What
So,
reply?
they have given a reply that our prayer for reconsideration for a reinstitution of a medical board, because our medical, everything has come clear, my lord. So they should reconsider our medical thing and check it up. And one post should be kept vacant till my thing comes out, because the one post should be vacant. And my lord, a medical board should be constituted to check, my lord, an independent board. That is, we wanted that, my lord, because the Jawaharlal Nehru Institute, my lord, it clearly states, my lord, it's a government thing, my lord. It clearly states that, my lord, it's a tier 1 hospital, my lord. It states that everything is clear, my lord. So after that also, my lord, that is why the Manipur High Court gave us a stay, my lord. Unfortunately, my lord, we didn't see that 10.35 clause. So
Now, where is
so
that?
therefore, my lord,
Your second representation, how it was
my
dealt
lord,
with?
this one, my lord, Annexure 11 is my second representation.
What was the response?
Their response yesterday I have got, my lord. I will have to take it out, my lord.
Where is that?
No, that is the reply. That is the reply.
Where is that reply?
That reply, my lord, I have to bring it in the form of affidavit. Till then, that is why, my lord. Till then, I'll bring it in the form, my lord. No, before he submits, my lord, I would, no, I have to convince the court. So, my lord, if lordship kindly indulges me, my lord. My lord, that reply, till date, they had not given us this 27/9.
No, you just directly come to the point. What was the reply?
The reply, my lord, that we have to check, my lord.
You are not aware.
Today I am not, my lord. No, I have been instructed. I have been told.
You are not aware about reply.
No. Today, my lord, they have given, my lord, yesterday.
I am not asking when it was given. I am asking what was given.
The reply, my lord, as far as my instruction goes, I will bring in, my lord, I will bring in the form of affidavit.
You are not answering.
No medical reinstitution can be done.
That is the answer.
They will not do anything, man. They will not consider.
Your prayer was rejected.
They rejected it out, and without any reason, man. Without any whatsoever reason. They just rejected it. So,
Yes.
my lord, I will bring that in future, my lord. In when this case is not going to get closed today, so I will bring that on record. What all they have replied, because and they have done it very distinctly, my lord. Because kindly see, my lord. Yesterday, when they came to know that I have filed a writ petition and I'm going to move it in the High Court here on the vacation board, then they give us a reply at my lord. Then they give us. So, lordship will kindly consider my case, my lord, and my lord will. My prayer, my lord, kindly come to us once, my lord. As before I kindly conclude, my lord. My prayer is simple, my lord. That which I prayed in the Manipur High Court as well, my lord. That, my lord, direct the respondent authorities to reserve one post of junior assistant fire service without filling the same, my lord, till the pendency of the repetition. Second, my lord, to constitute an independent medical board, man, because that will be very crucial. Because here, my prima facie, my lord, I have produced documents which show that I am eligible for, my lord, this thing. Therefore, for that, my lord, and my lord, also, my lord, this impugned communication which is there, that is 26/9/24 by email they have said, that may be quashed, but that may be stayed for the timing. So these three are the three pairs. Stay the impugned order 26/9/24.
No, that is not an order. That is a communication.
But my lord, that will affect me, man. That will affect me. So
Lordship, this candidature was rejected back on 22/8, Lordship. We have the instruction here, Lordship, in written form.
Now, what is your submission?
My submission is that, Lordship, we never communicated to him that he was suffering from bow leg, Lordship. We rejected him solely on the ground that he did not meet the height, Lordship.
But
His-
height, there is a
His height
concession.
is 163, Lordship. Will find that page 3 of the instruction, Lordship. Page 5, Lordship.
But he has produced document showing that his height is
Yes,
164.
I've-
No,
Lordship,
now you keep silent.
he brought it just after we told him in our reply that you do not meet the height criteria and eye criteria, Lordship. Thereafter, he goes to a hospital and he brings his requirement, Lordship, that he has 164. This was dated 22/8/2024, Lordship, wherein his height was found to be 163 centimeters, Lordship.
No, without verifying again, after getting representation, on what ground his representation was rejected?
Lordship, his representation was rejected on 26/9 on the ground that he did not meet the height criteria, Lordship.
No, second representation.
Second representation was second one. Second one from Kotak.
Because first, you never, according to him, you communicated only regarding bow leg in that too,
Goal
or,
we have
or
never communicated.
never
with him.
communicated.
There is no basis regarding that statement. It is just a simple
Okay,
statement. Lordship.
that we are ignoring. Suppose we,
Lordship.
if we, even if we ignore that.
Yes, on 11/9, he files a representation. On 26/9, we replies to his representation stating that.
But he filed a representation on 27/9. 27/9,
Yes, Lordship.
stating that he had undergone medical test in Jawaharlal Nehru Institute of Medical Sciences.
Lordship, that reply, your Lordship will find at page 12 of the written instruction, Lordship. Our reply.
That has not been now furnished to me till date.
What furnished to you? It has been emailed. What are you making?
No, don't
statements?
talk amongst yourself.
You are making such statements.
Yes,
Lordship, this is an email, Lordship, which was sent from us to the petitioner, Lordship. May I read, Lordship?
no, what was your reply to that? His representation, second representation.
The decision on your disqualification for further stages of selection process is as per reports of the medical authority, authorized government Dr. Agartala. It is apt to mention that the medical examination at Agartala of the candidates has been conducted by expert team of the government doctors of GBP Hospital and Government Medical College, Government of Tripura, Agartala, duly authorized by Director of Health Services, Government of Tripura, Agartala. In view of the above, your request for arranging an independent medical team for examining the fitness as to height and eye cannot be considered at this stage, Lordship. And moreover, Lordship, yesterday the select list have already been published, Lordship, on official website of AI, Lordship.
My lord, look at the
And-
conduct, my lord. Yesterday.
But look at the conduct. We have
My lord,
been
we have
approaching Manipur
withdrawn-
High Court,
we have-
knowing that Honorable
knowing
High Court did not have any jurisdiction, Lordship.
He-
He has withdrawn a writ petition on 26/9 and thereafter again on 10/10 he files another writ petition there, Lordship.
Right.
In one court where there is no jurisdiction, Lordship. And he comes today, Lordship, on a vacation court seeking that one post has to be reserved.
My lord, why not?
Select list was already published yesterday, Lordship.
My lord,
And
look at the,
appointment orders have already been issued.
my lord, how can, my lord, that is,
No,
that is
you-
again.
you please don't interrupt in between. You have taken sufficient time. If I have any, if I have any query, I will ask you. You don't please. Now, what would happen to that?
He has to
There is-
come up with another repetition, Lordship. This has already become in
No,
practice,
the report of
Lordship.
Jawaharlal Nehru Institute of Medical Sciences.
In that case, he has to make the select list a party, Lordship. Third party right have already acted.
May I? My lord, regarding that, my lord will kindly have this. This has been done, my lord. They are trying to, and again, I would like to just beg your indulgence, my lord. They are trying to bulldoze, my lord. Yesterday, the stay was there. Yesterday evening, the stay was.
Where is the select list?
Lordship, that's Lordship, select list is here only. with the
My lord will
instruction.
kindly. help me,
Last
my lord.
page, Lordship.
They have taken out this list, my lord. My lord, they have taken out this list yesterday after the order has been passed, my lord. They know that we'll be filing, my lord.
No,
a
but
thing.
select list is already issued.
Even though select list is out, the appointments have not been given.
Appointments have been issued.
My lord will kind, that is the thing, my lord, they're trying to bulldoze again. I would like to show their own document, everything I'm showing their own advertisement, they have made the rules, everything they are violating. Here there is my lord, this is a 26-year-old boy, my lord. His career is at stake. They're playing with his life, my lord. They will issue all this. So therefore, my lord, my fundamental right, my lord, has been violated, man. This has to be seen, my lord. They are playing with the life. Kindly see, my lord, I will show with their document, this document which they are talking about, the select list. Kindly see the second page, my lord. The second
You
page, my lord.
constitute a medical board
Exactly, Lordship.
and again check his height.
Yes, ma'am.
That will solve the problem.
Yes. And my lord, just one thing I want to show, my lord, one thing. Paragraph 3,
No,
my lord.
you please don't interrupt. Otherwise, I will dismiss this expectation. You constitute a medical board. You take time
Lordship, but
because now appointments is yet to be made.
appointments have been issued, Lordship.
They cannot make, that is what I'm trying to show, my lord. Paragraph 3 of that same order which I've given you now, my lord, that in the select list. Kindly come to, my lord, point number 3, my lord. Kindly come to point number 3, my lord. Yes, my lord. Point number 3, the above candidates are selected provisionally as trainees and the details
Yeah.
will be intimidated to the select, his own thing, my lord. The above candidates are selected provisionally as trainees, and the details will be initiated to the selected candidates on their registered email and ID regarding the basic training course shortly. On successful completion of the basic training, the candidates will be issued offer of appointment as junior assistant, madam. So after, if they don't do the basic training, madam, this is their own thing, madam. Kindly see, he is saying a false thing, madam. That
That
already
is regarding
appointment is given.
regular pay salary.
It is
Lord.
already given, my lord. So it is already given. That basic, after they complete the basic training, only then they will get their
Okay, heard
thing, madam. So my lord,
Mr. A. Fukon,
My lord.
learned counsel for the petitioner. Also heard Mr.
D Deka.
D. Deka, learned standing counsel, Airport Authority of India. This writ petition has been filed by the petitioner under Article 226 of the Constitution of India, impugning the. You have not brought on record many things.
my lord. No, my lord, this we have been, we have
Lordship,
got
one
the
thing I
website.
want to
This
point
has
out,
been,
Lordship.
No, in this manner, I will not allow.
My lord, just one prayer, my lord. This particular thing has been given to us in today morning. We have received it. They have uploaded it today, my lord. Because yesterday.
These are not on record.
No, my lord.
Lordship.
My lord, I'll bring it in the form of additional affidavit. Till then, my lord, the stay may be given. I will bring it in the form of additional affidavit. my lord.
Stay regarding what?
My lord,
Lordship?
stay and my lord,
Checklist is
one
already
Stay
out.
stay on what?
One post
And
vacant, my lord,
third-party
because
rights have already accrued,
no,
Lordship.
my lord. This thing itself shows, my lord. The advertisement itself, the select list itself says that without getting basic training course, my lord. Yesterday they have issued.
But select list is
Now,
already
my
out.
lord, kindly see their own document. Basic training on successful completion of basic training.
What was the last
So,
line?
my lord, how can he say, my lord? Lord, it's a candidate, my lord. He's a student, my lord.
I will dismiss this writ petition.
I'm sorry, my lord.
Impugning the communication dated 26/9/2024, whereby the representation, whereby the candidature of the petitioner was disqualified by the respondent authority on the grounds that the eyesight and height of the petitioner is not as per the requirement of the advertisement issued by the respondents. Stop. The facts relevant for consideration of the instant facts relevant in this writ petition are that the petitioner had applied to the post of junior assistant within bracket fire in the where in pursuant to the advertisement number 01/2023/DR/NER dated 30/12/2023 issued by the respondent authorities. And stop. The petitioner had qualified the written examination and was called for driving test and called for medical fitness test and physical endurance test on 21/8/2024. It is the contention of the petitioner that petitioner was orally informed regarding his disqualification on the ground that he was suffering from bow leg the petitioner, after getting the said information, approached where is your bow leg test? Approached
not
the
my-
Jawaharlal Nehru Institute of Medical Sciences, Parampat, and subjected himself to the physical test, and it was
Page 47.
and as per the test conducted by the orthopedics department of the said institute, it was informed that the petitioner was not suffering from any bow leg or knock knee or any spinal deformity. Accordingly, the petitioner Accordingly, the petitioner filed a representation dated 11 September 2024 before the respondent authority
Page 48.
informing about his medical fitness according to the report of the Jawaharlal Nehru Institute of Medical Sciences. However, he was informed. Where is the communication?
My lord, at page 50.
26/9.
How was
Page 50.
on 26? However, on 26/9/2024, he was informed by the respondent authority that according to the reports of the government medical authority, Agartala, comprising of different expert doctors, the height of the petitioner and eyesight of the petitioner was not as per the requirement of the advertisement issued by the airport respondent authority. Stop. Learned Stop. Learned counsel for the petitioner has submitted that after getting the impugned communication dated 26/9/2024, the petitioner again went to Jawaharlal Nehru Institute of Medical Sciences, Porompat, and subjected himself to his eye checkup and height checkup. And it was found that his eyes were found. Where is the advertisement?
So the advertisement is at page 20. Page 23 minutes. Page 23 minutes. Below physical fitness.
His eyesight were found within the parameters prescribed in the advertisement, and his height was found to be 164 centimeters. It is submitted by learned counsel for the petitioner that the advertisement also contemplates for a relaxation of 3 centimeter in heights for candidates belonging to hilly area, for bona fide candidate belonging to hilly area, and it is contended by the petitioner that he belongs to
My lord, page 55.
he belongs to Imphal West District of Manipur and also a member of Meitei community of Manipur state, and therefore comes within the purview of the relaxation clause of the advertisement. And if the relaxation of 3 centimeter is given to the petitioner, his height would be 167.5 centimeter. That is much
164.5.
167.5 centimeter.
167 is the
minus-
normal height, and
No,
for
if-
heels, it is 3 centimeter less, so it's 164. He contends that his height is 164.5
Fine.
centimeter.
As per the medical report.
Oh, his height would be more than the
Required amount.
required parameters of the advertisement. Learned counsel for the petitioner has also submitted that the petitioner earlier approached the High Court of Imphal by preferring a writ petition which was registered therein as WPC numbers 712/2024, wherein notices were issued to the respondent and interim relief was also of reserving 1 seat of junior assistant was also granted to the petitioner. However, as the advertisement also contained a clause that any litigation or any legal proceeding in respect of any dispute arising out of the advertisement would only be in the court within the jurisdiction, court situated at Guwahati. Therefore, the petitioner had withdrawn the said writ petition. With liberty to approach the appropriate forum. So, learned counsel for the petitioner has submitted that till filing of this writ petition, the fate of the second representation filed by the petitioner on 27/9/2024 was not communicated to him. When you came to know about the
My lord,
fate,
yesterday in the evening. I will produce that in the court
However,
of the case.
he submits that yesterday evening he came to know that his representation was rejected. The representation has been rejected, and he seeks leave of this court to file additional affidavit to bring on record the said fact. On the other hand, the respondent authority, which has appeared as caveator in this case, which had also filed a caveat and has appeared through Learned Standing Council Airport Authority of India, has submitted that in the meanwhile, the respondent authority has already issued select lists. When it has been issued?
Yesterday, Lordship,
No,
14.
no date is given.
1410, no, not there, but on the next page, on the last page, the Lordship will find it. The snapshot from the internet, Lordship.
Date is not there,
It's not there.
Your Lordship, it is here.
but
I've got the-
I'm representing,
The downloaded copy I have, man.
I am reflecting your submission
Lordship, on 14/10/24.
on 14/10/2024. And therefore he submits that the present writ petition has become infructuous. He has produced a copy of
Select list.
provisionally copy of the select list. In interim, what you can do? You can constitute
Lordship, we can constitute a medical
medical
board,
board.
but he has to make them parties, Lordship. Third party rights have already accrued,
My
Lordship.
lord, if I may allow.
No, I am not
My lord,
saying it.
third party right is not allowed, my lord, because why? The advertisement itself, I mean, not advertisement, the select list, kindly, I have given the copy of my lord, download copy. The select list itself says that the above candidates are selected provisionally as trainees, and the details will be intimated to the selected candidates on their registered email ID regarding the basic training course.
See,
On successful, my lord, on
the
successful.
advertisement was for how many posts?
46 posts for.
So one post, my lord, can be kept vacant, my lord,
But
until further
one
order.
post unreserved, reserved.
Because my lord here, my lord kindly see, on
No.
successful completion of basic training course, the candidates will be issued upon appointment. So till now, my lord, no appointment has been issued. So that is
You are agreeing to the proposal that a medical board may be constituted.
Lordship, that's what he is praying, Lordship. If it is,
But-
there is a conflict between, because both the certificates were, his certificates were issued by government doctors, Lordship. And his rejection is also done by government doctors of Agartala, Lordship. So
Lordship
even
can, Lordship
admit,
can constitute a board then, my lord. Lordship has the full.
our rejection dates back to 22/8, Lordship. That is there in the.
That he
instruction,
is
Lordship.
challenging, therefore he is before the court.
Yes, Lordship, but he has challenged it before the Manipur High Court twice. On the
That is a
first
different
day,
thing.
he withdraws the writ petition because that honorable court did not have jurisdiction, Lordship.
My lord.
Thereafter, he again
first one was the
approaches
bow,
on
my lord,
10/10.
The bow thing. So we have withdrawn there, and my lord, we have also.
Let him
because-
file a fresh writ petition,
Not
Lordship,
at all,
on
my lord.
reopening.
You
He's
take
taking-
we are issuing notice.
Lordship,
You take instruction
Lordship.
whether regarding the proposal of the court to constitute.
Lordship.
My lord, till then status quo may be given, my lord, because
No
otherwise
status quo.
they will, my lord, they will appoint otherwise. When they see, my lord, they have.
No,
They have-
it will be subject to outcome of this writ petition.
My lord, I pray that, my lord, one post may be kept vacant, my lord, because my lord, kindly once more, I just want to show one thing, my lord, that
No.
their select list,
Issue notice to
basic, my lord,
the respondents.
my lord, appointment is not there.
Since Learned Standing Council has appeared for the
I'll
respondent
be prejudiced, my lord.
authority, the formal notice need not to be issued. The notices are returnable on no, you take instruction.
Lordship,
During the course of the hearing,
Lordship,
a proposal was made by this court
Lordship.
that proposal was made by this court regarding constitution of a fresh medical board to recheck the height and eyesight of the petitioner on petitioner, since on those grounds his candidature was rejected.
My lord.
The Learned Counsel for the respondent seeks some time to take appropriate instructions. The The respondent authority, no, the time sought for is granted. On the next date, the respondent authority shall intimate this court regarding constitution of a fresh medical board for re-examination of the eyesight and height of the petitioner in light of the report of the where is your annexure? That Indira Gandhi Institute, Jawaharlal Nehru Institute.
Perfect, page 46. I think. Page 46. Page 52. Page 52, Lordship. Page 51, 52. Type copy.
51, 52. Man.
In light of the report of the Jawaharlal Nehru Institute of Medical Sciences, which has been annexed by the petitioner as a Annexation 9 to this writ petition. The petitioner may file additional affidavit as sought for by him. The outcome of the final select list, the final select list shall be subject to outcome of this writ petition. Please this matter again. When?
Lordship, on reopening, Lordship.
We will give a fixed date.
Lordship, just one thing, prayer, my lord. One thing I just want to say.
When you can intimate this court regarding
I will
constitution.
require 1 week, Lordship. So on reopening, this matter may be fixed.
My lord, till then, my lord, one post may be kept vacant, my lord. If I my
Till
humble
then,
prayer-
nothing will happen.
My lord, why I'm saying, my lord, they've already issued this thing, my lord.
On
select
25th.
list.
On
25th.
They've
on
already
25th.
25th.
They've taken out the select list. Till then, my lord, protect me, my lord. Kindly protect me.
I'm
because,
highly
my lord,
obliged, Lordship.
my lord, they have
Obliged.
also given one thing out here, my lord. That
I have given sufficient protection to.
my lord, the basic training course, my lord, thing is there, my lord. That is all appointment regarding the offer of appointment. That part,
80
my lord, till
people
then,
were
my lord,
rejected, Lordship.
kindly, my lord, that's why, my lord, because independent inquiry should have been given, my lord, instead of them, my lord, again they will reject, my lord. So
Let us see.
my lord,
On
kindly-
25th.
25th.
Obliged,
Till
Lordship.
then, my protection, my lord, till then, my lord. Please,
I
my
have
lord,
given sufficient protection.
that they don't, my lord, issue order of appointment. My lord.
Obliged. Lordship, only. Lordship, this subject to the outcome of this writ petition, this interim may be protected for only for him, Lordship. Because 80 candidates have been
Yes.
rejected.
Yes.
Others might also come, Lordship.
Therefore, my lord, I paid, that's why my point.
On 20, you are going to issue an appointment letter again. No,
No, Lordship. Appointment letters have already been issued, Lordship.
this is provisional training. The select list is only for provisional training.
We'll highlight that. Your lordship, this is deeply obliged.
When this petitioner saw Gao Panchayat level Samavai Samiti, my rule is that, my lord, they are to lift and they are to distribute
No,
the.
who
food
are the
grain.
petitioner?
Yes. petitioners.
Samavai Samiti.
Yes. Now, your lordship, kindly see, my lord, similar what I think my that will do, my lord. Your lordship, kindly see page 91. Sorry, page 105. I think if my line of friends agrees, my lord, page 105. Order dated 28/8/24.
Yes, what is this?
Yes. Same matter, we stand on the same footing, my lord. Petitioner's case is that the state respondent cannot employ private transporters, contractors for lifting and transportation of essential commodity from the Food Corporation of India storage depot to godowns and to the fair price shops pursuant to the NIT dated so and so. As the same is in violation of order so and so of targeted public distribution system, the Grade 2G of
The
target.
NIT is also same or different NIT?
Same.
Same NIT.
It is pending.
No, not same NIT, similar.
Similar.
Similar, my lord. Text is almost same. Your lordship, what happened, my lord? Normal rule is that my Panchayat is to distribute, is to bring from FCI to their godown, from godown to fair price shop, then to the benefit consumers. So this is for last several decades, but it is continuing. NFS Act came into effect in 2013.
Which act?
National Food Security Act.
Okay.
So under that, my lord, those steps deliver. It is to be given. So in 15, what they did, they tried to introduce a contact system of private arrangement. This honorable court, there some of the petitioners came before this honorable court.
Earlier.
Earlier, single bench dismissed that man. They have gone to the appellate court, WPC. WPC said no. The present system will continue, and on the basis of that order, my lord, this order has been paid. Now WPC order kindly see my page 92, 91. 105.
Which?
Page 91. T918, my.
Yes.
Yes. Your lordship will find that when a single bench dismissed the petition, man. So, having regard to the facts and circumstances of the case, and also considering the fact that appellants are continuing to lift and distribute the food grains from the designated depots, we direct the parties to maintain status quo in respect of the existing system of distribution of the PDS commodity insofar as the transportation is concerned till the final decision of the appeal.
Writ appeal.
Return it. It is still pending. On the basis of this, my lord, 105 whatever all issue that we just now hear your worship point. So we stand on the same footing. Another case is also there, my lord, I have done that case, my private was your employer, appointed, that was stayed by this court, that also I have annexed. 113, my lord.
In the instant case, what has happened?
NIT was issued, and one person, respondent 7 was selected.
Private person.
Selected, but not yet been allotted. Because it is allotment is made subsequent.
And that matter is still
All the matters are
division
still,
bench.
all
We
the
take together.
three matter, WPC, single bench, the present 113, that is also pending. All the matters are pending. And all the matters are, my lord, in terms of writ appeal, page 92.
Yes.
Lordship, it may be take together, Lordship. Otherwise, Lordship.
Page 90. Or 105, ma'am.
What is 91?
91 is the writ appeal
writ
order.
appeal.
Writ appeal order.
It is mentioned here, my writ appeal also mentioned in page
105.
105, 106, writ appeal is also mentioned. Page 106, paragraph 3, man. He further submitted that similar matters had been decided by single bench. The lead case being so and so here, and the petitioners therein who were similarly placed as the petitioner had made a challenge, statement to engage so and so. So the single bench.
Your
by
NIT
judgment-
was also 8824.
No,
Yes,
no,
no. 38, 30, 30.
30, not.
Our
600.
access. So singular dismissed, being agreed, they have gone to division bench. Division bench by order 3918. Same are the principles say.
Okay. Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. R. Islam, learned counsel for the petitioners. Also heard Mr.
SS Roy.
S.S.
Roy.
Sharma, S.S. Roy. Learned
State Council Lodge. For respondent number 2, 3, 2 to 6.
Online.
2 to 6.
Oh,
Learned
yes, 7 is.
counsel for
Two,
learned government advocate
Lordship. 2 to 6.
appearing for
2 to
respondent
6.
number 2 to 6.
2 to 6. One CJC will serve point. A 7 will go by registered.
Okay. This writ petition has been filed by the petitioners. Impugning the order dated 8
Page 7 to 8, 10, 24.
8/10/2024 issued by the
Respondent number 6.
respondent number 6 in pursuant to the impugned NIT dated
Lordship,
38.
that was not in terms, because the NIT process was not yet completed. This was not to that process, Lordship.
No,
NIT.
But that they are claiming.
well, sir, completed.
That is the claim of
Yes, yes, completed.
NIT dated 38/2024,
4.
by which the private respondent number 7 was allowed to transport food grains under NFS Act 2013 in the South Salmara, Bankachar district. The contention of the learned senior counsel for the petitioner is that state respondent cannot employ private transporters / contractor for transportation of essential commodities from Food Corporation of India's storage depot to godowns and to the fair price shop, as same is in violation of these provisions are applicable.
Yes, same.
Same is in violation of order 7 within bracket 1, 7 within bracket 11, 8 within bracket 1, and 8 within bracket 3 of the targeted public distribution system within bracket
2015.
control order 2015. Read with order 2 within bracket small g of the targeted public distribution control order 2015. Learned senior counsel has, for the petitioner, has also submitted that the impugned order would be in violation of section 24 within bracket 2 within bracket small a of National Food Securities Act 2013. This writ appeal number is
Yes, it have been number is 249.
297 of 2018.
106 it appears, man. Page
so
106. Oh, that is page 10.
page 106 para 3 would be applicable
Yes,
in this case also. Quote para 3 from page 106 of the writ petition.
yes, ma'am. Exactly.
Issue notice to the respondents returnable in 4 weeks. Since Mr. S.S. Sharma
SS Roy.
S.S. Roy has appeared for respondent number 2 to 6. No formal notice need to be issued to said respondent. As regards other respondents, the petitioners,
One will serve because the union standing council is here, ma'am.
as regards the petitioner,
7 registered posted.
as regards petitioner number, respondent number 1, the notice would be served by the petitioner to the standing counsel of the petitioner number 1. As regards petitioner number 7,
Respondent
the
was
notices sorry, as regards respondent number 7, notices with regard to said respondent shall be sent to registered post with AD within 7 days from the date of this order, returnable after 4 weeks. Code para 6 from 106. Next, in view of the
dated will be 38.
in view of the division bench of this court, comma, in writ appeal number 249/2018, directing that the lifting and distributing of food grains from the designated depots should be carried out as per the existing system of distribution, comma. This court is also of the view that NIT dated 38/2024 cannot be acted upon till a decision is taken by the division bench of this court in the above mentioned appeal, writ appeal. List this matter accordingly after 4 weeks.
Let the matter may be tagged together Lordship with this.
Respondent number 7, my lord, allotment has not been made, but selection was. Whether some clarification may be required, my.
No,
Not to be acted upon.
not to be acted upon. That will cover.
That will.
That will cover.
Obliged.
It will
This,
be tagged with
let this writ petition be tagged with
WPC number 4334 of 24.
WPC number 4334
424.
of
4334 of 2024.
2024.
Obliged. 7,000. Transfer order. May I please, lordship? The land matter, lordship, I have received a notice for demarcation of my land, wherein the circle officer Dhubri has directed demarcation of my land on 19th of October, which is during the vacation, lordship, of this court. Now, lordship, why I have challenged this notice for demarcation is the demarcation already stood completed in 2023. Notice that I am challenging is at page 47, lordship. At page 47, lordship, the notice states the name of respondent number 4 and 5 as the first party who have filed the demarcation application, and second party, me, that is the petitioner. Date has been fixed on 19th October, lordship. Now, lordship, just before that page on page 46, the demarcation proceedings should completed last year. The order is there. Page 45 is the translated
In
version.
respect of the same land,
Same land, lordship will notice the particulars on page 47, dark number 633. Area of land 3 kothas, 16 lachas.
this is a writ of certiorari.
Lordship. And lordship, the order which has been accomplished in 2023, the demarcation on page 45, it is of the same land, dark number 633. Wherein a specific report has been submitted as regards the area of land in possession of the first party.
This demarcation was in pursuant to which order? Which authority ordered?
Same authority, lordship, Circle of Dhubri, who has issued the notice now, lordship. There is an application for demarcation enclosed with the notice page number 47, lordship. It does not spell out any reason why a fresh demarcation is required, lordship. So I am just seeking that further proceedings of the fresh demarcation case kept in abeyance till that petition is decided, lordship.
Let me have the instruction on that, Lordship, because I have to take instruction on that. Why this second notice has been issued?
Once it has already been completed, lordship, no prejudice shall be caused if the further proceedings is kept in abeyance, lordship. Demarcation case number 18/24, page 47.
Heard Mr.
D. Saraf.
D. Saraf, learned counsel for the petitioner. This writ petition has been preferred by the petitioner, impugning the notice issued by the circle officer Dhubri that is the respondent number 3 in demarcation case number 18/2024, fixing 19/10/2024 as date of demarcation of the land measuring 3 kata 16 lechas covered by dag number 633 of patta number 962 at village Dhubri town, Khas Mahal. Learned counsel for the petitioner has submitted that the land sought to be demarcated has already been demarcated in pursuant to the earlier order of the circle of respondent number 3, which was passed on 19/1/2023. Stop.
In demarcation case number, Lordship, it was separate case number,
In demarcation case number
07/22.
07/2022. Mr. S.S. Sharma, sorry, S.S. Roy, learned counsel for the state respondent, within bracket respondent number 1, 2, and 3.
2 and 3, Lordship. One is standing counsel, revenue department.
One, respondent number 2 and 3 sought some time for seeking necessary instructions in this regard. Issue notice to the respondents. Since Mr. S.S. Roy has appeared for respondent number 2 and 3, no formal notice need to be issued to the respondent, the said respondent. As regards respondent number 1, the petitioners shall furnish notice along with a copy of the writ petition to the Standing Council of Revenue Department. And stop. The petitioner shall also take steps for issuance of notice on respondent number 4 and 5 by registered post with AD within 7 days from the date of this order, returnable. When the date is fixed,
It is fixed on 19th of October, Lordship, the demarcation case. It has to be fixed after it, Lordship, to maintain protection.
returnable on 30th of October. In the meanwhile, considering the submissions made by learned counsel for the petitioners, as well as averment made in the writ petition, the
Further proceedings, Lordship.
in the impugn order dated
Notice. It does not contain date, Lordship, notice.
Okay. Then
Demarcation case number 18.
the status quo shall be maintained in respect of the demarcation case number 18/2024 till next returnable date
By the respondent authorities.
by the respondent authorities.
Highly obliged, Lordship.
By the peculiar circumstances, I have to trouble you, Lordship, in the vacations period. But the petitioner is having a warehouse on lease from the private respondent. Now certain disputes were going on with the private
Lease of land,
warehouse. my lord.
warehouse.
Warehouse.
Okay.
Now, my lord, certain disputes were going on, and accordingly, the private respondent filed a suit. Page 24, your lordship find. With a prayer for eviction of the petitioner, your lordship find page 63, the prayer.
Yes.
Now, the suit is still pending. Fixed on 30th of October for hearing on the maintainability of the suit. Now, in the meantime, what happened, my lord? There was disputes, my lord. We started creating the disputes, my lord, with regard to electricity, all those things, my lord. And we are constrained to be a file a writ petition before this honorable court. At page 119, this honorable court protected us because he was not allowing the meter reading, etc. So APDCL issued a notice for disconnection. And ultimately, this honorable court protected us. And thereafter, the things were sorted out. Notice could be in the meantime, the petitioner also.
What is the registration number of the suit?
Registration number.
One, commercial suit number one.
Yes.
Okay.
Commercial suit number one. It is not.
Now, my lord, because of all the inconveniences which were caused to the petitioner, my lord, petitioner at page 98 will also find served a notice, 6 months notice for vacating the premises. That was on, my lord, 16th April 2024. So all throughout he was creating the problems. So on 16th April 2024,
Private respondent served you a notice.
my lord,
Who served it?
this petitioner served a notice to the council, my lord, solicitors on the private respondent. 6 months notice for vacating the premises. This was on 16th April.
Who has leased out the warehouse?
Respondent was private respondent, respondent number 6.
Respondent number 6. North Kachar Civil Limited. The plaintiff in the commercial suit.
My lord, my lord.
Okay.
Now the notice was given at page 98, my lord,
Notice was given to you.
to the private respondent by us that we shall vacate the premises, which is 6 months notice.
You are giving notice that you will vacate the suit premises.
My lord, because
You
the
are seeking time.
6 months time was, my lord, notice was given.
Okay.
Now what happened, my lord, because the difficulties, he was always creating 5 days, he closed anything Instacart. The lordship knows that all the goods which are coming for distribution and all those things, they will get difficulties. Now what happened, my lord? In the meantime, at page 124, your lordship may see.
Yes.
He put up a notice on the near the warehouse that no mail materials, trucks, staff, bus, cars, two-wheelers, food trucks, etc. will be allowed to enter the gate from 16/10/2024. No one inside should leave. Anyone inside shall leave by 10 AM on 16/10/2024 or at own risk, and vehicle will be retained.
The private respondent put up these notice.
Notice.
Okay.
Now, my lord, findings all the difficulties, my lord, we by letter dated 7th October, you'll also find it page 128. We had withdrawn the notice.
6 month notice of vacating the suit premises.
My lord.
Okay.
That was withdrawn on 7th of October 2024. Now, on withdrawal of this notice, my lord, the private respondent, you'll also find page 133, communicated that withdrawal is rejected by them.
Okay.
And side by side, you'll also see
No,
page,
just before that,
my lord.
when have you issued notice, 6 month notice?
Well, that was 7th of, not right? Huh? 16/4/2024.
So you will be completing 6 months by 16/10. Okay. So by your own notice, you will be completing that 6 month period.
And we on 7th itself, we have withdrawn it.
Okay.
7th October 2024, we withdrew it.
Okay.
Now, I am not going into, my lord, all those because this is the matter which is the ultimately, but the question is that, my lord,
An eviction suit is pending
pending,
with regard to said same premise.
same premises. Now, 133, my lord, he said, I withdrawal letter, which is that it is rejected. How a private respondent, why my withdrawal letter, who is he to reject it? And not only that, my lord, what he is saying, you also can see at page 134. Last three lines, my lord. No operations shall be allowed to be carried out from the demise premises and property under any circumstances from 16/10/2024 onwards. Will take all necessary measures rightfully available.
Where 134
Last three lines, my lord. 134.
yes.
No operations shall be allowed to be carried out from the demise premises and property under any circumstances from 16/10/2024 onwards. We will take all necessary measures rightfully available to us to prevent. And thereafter, you also can see at the 135, the last paragraph, my lord. Lastly, in view of the rejection of the notice of withdrawal, that is 7/20/24 of notice to vacate the premises on so and so by us, you are required to communicate to your client that they are strictly required to take the matter seriously and legally bound to vacate the site without fail on 16/10/2024 and refrain from illegally occupying, encroaching, trespassing the same without any legal right to do so. Your client is urged to support and cooperate in the matter, maintaining law and order and peace and harmony in the area on 16/10/2024 onwards. Your client so-and-so will solely be responsible for any incident, untoward incident, loss of life, any kind of loss to the demise premises or property of so-and-so, or loss of event so-and-so, and for any kind of violence or unlawful behavior on the part of the workers, staff, members, drivers, security staff, and directly employed on the contract basis and so and so. So, my lord, he was saying all those things that there will be law and order situation, there may be this, that, failing which, my lord, no other alternative. My lord, we addressed a letter to the officer in charge of the police station. Because ultimately, my lord, ultimately, when he's saying about the breach of the 156, you'll also see, we intimated to the officer in charge, but that officer in charge refused to accept our complaint. Once it was not accepted, we sent a email to the Supreme Police, which you'll also find at page 161. But we also approached the Deputy Commissioner, my lord, under section 164 of the new act, which is parliamentary to section 145 of the CRPC. But Lord, the Deputy Commissioner was out of station, and you also may see at page 155. We sent a WhatsApp message to the Deputy Commissioner also, this is urgent. And at 155 in the middle, you'll also see he writes, my lord,
Page number
135, 155. It starts from 154, my lord. That we send a message to the Deputy Commissioner that it is urgent and we have filed a petition. And ultimately, he says at part 155, okay, but I'm on leave till 17th. We also requested
the eviction suit is pending between the parties.
with the party, my lord.
So the commercial court will decide the dispute.
Now, my lord, I am just, my lord, I gave a notice before expiry of the period, I withdraw it. Who is the private respondent to reject it? And say that, my lord, the law and order situation will be there, the peace, harmony, and the workers. This is a dangerous situation.
Now, whether writ petition lies against private respondent.
I'm not talking about the private respondent, my lord. I'm not against the private respondent. That's why, my lord, I am against the authority because I approached the authorities, police authorities. He's not accepting my lord, this complaint.
145, 164.
Well, 164, I approached the deputy commissioner, he's not available. Police, I lodged the complaint because he is threatening all those things. They have not accepted. We intimated the Supreme Police also, and the Supreme Police also has not taken any action. Now he is saying that on 1610, I will do all those things and throw it out. Under such situation, the question is private respondent, if the dispute, other disputes will be civil dispute. They will go to the civil court. They will do everything. In the similar situations, the apex court has also considered it.
Now, what relief you are seeking?
Well, one relief is that the police may be directed for protection because this honorable court on the similar situation will not also pass the order. And secondly, that the eviction and all those things shall be subject to the outcome of the pending suit.
Yes, that is as because
Some protection, if it's not given, my lord, then it will be very difficult.
no, but regarding for jurisdiction of this court,
Well, jurisdiction, Your Excellency,
writ proceeding whether it is maintainable.
well, this is not against only the private respondent. I am coming that against the threatenings and all those things. I went to the police. Now, if law and order situation, he's saying law and order situation, peace, break of peace, and all those things. Well, what will happen? Not allow the operation, everything. I have gone there. I have gone to the DC for 164 proceedings. The DC is not available. And if some protection is not granted to me, then tomorrow, my lord, there is a breach of peace. Law and order situation is created.
So when the commercial suit is pending, why can you not seek any relief before that commercial court?
Well, the court is closed.
28.
Up to 28th. The DC is not available up to 17th. And the person concerned losses is see the conduct. I withdraw it, he rejects it. Who is it to reject? He can challenge it. Nobody can say that no, he cannot challenge it. Option is available with him.
No, but that is a dispute between private parties.
I understand, my lord. I'm showing the letter, your lordship will see this order. I'm just showing you. This was also this on the court. They are not accepting my lord. Para 3, your lordship will see. From the materials available on record, it is
Now to whom, suppose you question of maintainability, if we keep it
open, my lord.
open,
My lord.
then what interim relief?
You will also see the here also the
Against whom interim relief you are seeking?
I'm seeking the direction to the police. You will also see, my lord. You will also see. Last paragraph.
Police, because why? Is there any threat of?
Certainly, my lord, the threat, breach of the law and order situation. He's saying that I'll throw your boots and all those things. The drivers, the workers, all he's threatening. In writing, he's giving. And I've taken all the steps, whatever is available with me. I have not come directly before this on the court.
Okay, then you satisfy this. When private respondents are involved.
Well, here also the private respondent was there. Well, the private respondent cannot take the law and order situation in his own hand. If your lordship permits me, my lord, I may place few decisions.
Now your grievance is against police of not registering the FIR.
Fire and protecting.
Against SP, not taking any steps on your
Actually, my lord.
on the email,
My lord.
which was, and against DC.
DC
Taking
either if
plea
he is not
that he was
available.
on leave.
If he's not available, somebody has to interest someone.
But when commercial suit is pending, 164 otherwise also
commercial shoot, my lord, because of the threatenings, breach of peace, we can certainly move 164, my lord. Even if the shoot is pending, then also we can move for the breach of peace. And the Supreme Court and other courts all have said. Don't want, my lord, that, your lordship should decide the dispute. Who is ultimately we have to go to the civil court and all those things, we have to decide it. But the situation is that, my lord, tomorrow is the 16th. And he's saying, my lord, that tomorrow itself morning, I'll do all these things, law and order situation, breach of peace, the workers and all those things, they will all be affected.
Where is that language?
You also see, page.
Any kind of violence, unlawful behavior.
I'm seeing, my lord, you'll also see the letter at page 135, 11 part, my lord. It starts from 134. Last paragraph, my lord. Last 5 lines, your client so-and-so shall be solely responsible for any incident, untoward incident, loss of life, any kind of loss to the demise premises, property of so-and-so, concern any kind of violence or unlawful behavior on the part of so-and-so. In writing, somebody is giving, maintaining law and order. I've never heard of, my lord.
No, they are saying that your violence from on your part.
My lord, your lordship can see. What he is saying, lordship, just see, my lord. In first, you are required to communicate to the client that they are strictly required to take the matter seriously and legally bound to vacate the site without fail and refrain from illegally occupying, encroaching or enforcing site without any legal right to do so. Your client is asked to support and cooperate in maintaining the law and order and peace and harmony in the area in 16/10/2024 onwards. First of all, what peace and harmony, my lord, I will do it. He will create all the nuisance and he says that you maintain the peace and harmony. One 34 also you say one paragraph, my lord. One 34 last 3 lines, my lord. Can a person take law in his own hands, my lord?
No, okay, that I want to understand. During the pendency of the civil suit,
my lord,
they have stated that you cannot enter
my
from
lord,
so and
my
so
lord,
date,
my lord.
so and so date.
And he
So
has put the-
otherwise, relief is before that civil court.
Yeah, my lord.
Now, to invoke the jurisdiction of this court, that you have to satisfy that under what circumstance this court can invoke writ jurisdiction.
My lord, this jurisdiction, your lordship is not deciding the issue that whether the person vacation, the ejectment and all those things, your lordship is not deciding here. That will be subject matter of the commercial suit. I'm not asking your lordship to, not praying before your lordship at all, that your lordship will decide those issues. My only difficulty is that, my lord, at present, during the vacation, the 16th is coming, and he is saying that you cannot enter and they will peace. The obligation to maintain the breach of peace is also on me. He will enter, he will lock it. He has clearly put the banner, my lord, there itself. Now, under such situation, I approach the police, I approach the SP, I approach the DC. What more I can do? If tomorrow, my lord, something happens, then where I will be, my lord? If I would have prayed something against the private respondent, something that no, his order of rejection is illegal, etc., your lordship will not interfere because that is a civil court matter. But the question is about the law and order situation. And the apex court and other courts have all said, my lord, the law and order, all the situations, they have to do it. So Supreme Court. Your lordship may see one judgment, my lord. You know? para 8, my lord. Mr. So-and-so, the appellant here, my lord.
Your
Have you
rel-
got it, my lord? Para 8. May I read, my lord?
No, you have to satisfy one thing, that my understanding is under the facts which you have narrated, the relief lies before the civil court, the commercial court.
My lord, if you
Now
want-
the courts are closed. You apprehend that till reopening, there may be law and order situation. Therefore,
you are intimated,
you approach police.
my lord,
Police is refusing to register FIR.
not accepting also.
So writ court can invoke its
My
jurisdiction.
lord.
That you have to satisfy.
You also, that judgment itself, you also may see that I have given the single bench judgment also.
What para 8 says?
Para 8, you also may see. Case 4, so-and-so Learned Counsel as appellant has rightly did not go into the application of the evidence either by trial court or the high court, or the factual conclusion drawn by them. It was however strongly urged by that in the period of license had expired long back and the plaintiff was not entitled to renewal license. It was submitted by them that in view of the license having come to end, the plaintiff had no right to remain in charge of the business or premises where it was conducted, and all that the plaintiff could ask for the damages for the unlawful disposition, even on the footing of facts as found by the High Court. We find ourselves totally unable to accept the submissions of so-and-so. It is well settled in the law of the country that where a person is in settled position of the property, even on the assumption that he has no right to remain in the property, he cannot be dispossessed by the owner of the property except by recourse to law. If any authority were needed for that proposition, we could refer to the decision of the division of this court in so-and-so. The court in that judgment cited the approval, the well-known passage from the Privy Council in the case of so-and-so, where it said in India, persons are not permitted to take forcible position. They must obtain such position as they are entitled to through a court. Now, on maintainability, melody, also analysis. You'll also see para 29 mirror.
Of
Para 29, I'm sorry. It was last contended by the learned government pleader that the petitioner should have applied to the magistrate to redress and that he had not availed himself of the alternative remedy open to him under the law. This court should not use the discretionary power of issuing writ of mandamus against the respondent. We do not think that the failure of the petitioner to approach the magistrate in a particular case either debars him from the approaching this court or debar us from exercising the discretionary power of issuing a writ. The most expeditious remedy contemplated by law and the right of protection given by law is that of approaching the executive officer like the police. The various provisions of the Code of Criminal Procedure and the Massive Police Act do indicate bifurcation between the powers and duties of the police and those of the magistrate. The nature of the remedy sought for by the aggrieved party is also a decisive factor. The most expeditious action contemplated by law is to approach the police, who then are, if satisfied that the cognizable offense are being committed, can take expeditious preventive measures and also punitive actions measures. In the present case, what has been sought for is the preventive measure, preferably for removal of the dismissed worker from the premises of the factory to facilitate the working of the factory. Even if the magistrate were approached by the petitioner, the magistrate would have to direct the police to make an inquiry and submit a report as to what is required to be done. In other words, the magistrate himself has got to see that his order is executed through the machinery of the police. That is why the cognizable offenses, the law requires the police to take action without waiting for the offenders to orders of the magistrate. For the reasons cited above, we have come to conclusion that a writ as prayed for will have to issue.
no, here the question of alternative remedy is discussed.
That whether writ is maintainable or not.
Against private person.
Well, here also you'll also see this was a private person. He said that writ will maintainable. I am not issuing direction to the private respondent. I am not seeking for a direction to the private respondent.
What interim relief you are seeking?
Police direction to the police to give protection, to prevent the the threatening which is there, the breach of peace and the law and order situation.
Yes.
My lord, if my signature is done, then may I submit, my lord?
Yes, yes, ma'am.
My lord, what I could understand from this rate is, this is not maintainable, my lord. This is a classic case which should be dismissed as a very threshold. This is a very private dispute between two parties, my lord, and where they are trying to put the gun on the police and seek an order, my lord. My lord will come to page 131 that they have written to the police. Just I was going through, my lord, this page 131 of the writ. My lord is in page number 131. My lord will see it is addressed to the station house officer Amingao. Subject is what, my lord? Intimation regarding withdrawal of termination and continuation of tenancy.
Not read, you read the police, this is earlier one, 156. This is one, this one also we informed, 156 is the complaint. This is not the complaint.
My lord, let me start it from there.
You can-
My lord. So, my lord, basically on 7th October 2024, this is what they have intimated to the police.
No. What I have understood,
My lord,
there is a private dispute.
my lord,
There is a ejectment suit pending before commercial court.
exactly, my lord,
Now courts are closed
closed.
and he gave one notice of vacating the suit premises in the month of April,
My lord,
which is going to
expire tomorrow.
expire tomorrow.
Tomorrow.
But before that, he
Withdraw
withdrew
it.
that notice.
Yes,
So this is the subject matter of the civil suit.
civil suit. Exactly, my lord.
Now, he withdrew this notice. Now matter is still pending before the commercial court.
Exactly, my lord.
Commercial court will decide.
They will
But
decide.
you have put up, the private respondent have put up a barricade in place in form of a notice
My lord,
that nobody shall enter.
my lord.
And he has given a communication to the petitioner
My lord,
saying that in case of a loss of life,
my lord.
some
is
kind
the-
of threatening.
Yes, advocate's notice, my lord.
Yes.
Yes, my lord.
Where certain apprehensions are made.
Yes, my lord.
Therefore, he approached police.
My lord.
Now, police is not acting. Courts are closed. Under such circumstances, whether writ court can issue direction to police in such a,
To, my lord, to what extent, my lord? Their contention is that they have approached, my lord, and police did not register their case, my lord. If it is so, my lord can always direct to register the case.
Tomorrow, my lord, if the law and order situation is there, well, I'm just asking, I'm not interfering, my lord. I approached before this honorable court also, my learned friend is also appearing. Tomorrow, as per his threatenings, law and order situation arises. My lord, something happens there. Now they are saying that no, nothing, no protection should be there. Then after happening, I approach this honorable court also. Can this honorable court shut his eyes, my lord, and not direct the police?
whether pending question of maintainability, interim relief can be granted.
My lord, in your lordship, my lord, every case, the question of maintainability is left open. Every case, your lordship is passing the orders, that question of maintainability will be decided. Because otherwise, my lord, maintainability, the question is that, my lord, for immediate relief. Otherwise, I have not approached before your lordship in the vacations.
Yes.
There was no necessity at all.
My lord, to that extent, my lord, relief. My lord will direct police to register FIR, and accordingly, the law will take its own course. Once the FIR registered, the police will take it, my lord, legal steps. What is to be done, my lord? To that extent, my lord, there is no dispute. They are aggrieved. Any citizen can approach the police station, my lord, for protection. And police will, my lord, accordingly, they will, my lord, register a FIR and they will take steps. There is no denial on this, my lord.
So he's conceding that directions can be given.
To that,
Whether-
only to the extent, my lord.
No, whether status quo be directed to be
My
maintained.
lord, status quo in what regard, my lord? This is a private dispute, my lord.
No, unless that order is granted, there is a possibility of breach of peace. Because that is the apprehension.
My lord, my lord, now this is two situation, my lord. When police steps in, my lord, they can control the situation, my lord. Status quo, my lord, regarding the property is a separate issue, my lord. My lord will not entangle us. We are not a party to this. Police administration is not a party to their private dispute, my lord. We can always be there, my lord, to maintain the law and order situation, but we cannot be the party to their disputes.
Where in a dispute, state is a respondent and private parties are also respondent to that proceeding.
Yes,
In this writ proceeding,
my lord.
state is a party
My
and two private parties are also there.
My lord.
So their relief is, they are seeking relief against state. But unless some instruction, direction is given to the private respondents, the relief granted against the state may not be efficacious. Under that circumstances, whether some restraint can be put to the private parties in a writ proceeding, that is my query.
I am
My-
living, I am living at your lordship, but
No,
my
no,
lord,
you
we
insist.
want to get entangled in their private dispute, my lord. Yes, regarding law and
Private
order
dispute is
situation,
to be decided by the commercial court. But considering the circumstances that unless the private respondent are restrained for till the commercial court reopens, there is a possibility of
30th October, the date is fixed, my lord, for the shoot.
my lord, the thing is that
And my learned friend is not appearing for the.
I am not
Private
not holding the
respondent.
brief for private respondent. That is
No,
what
no,
I do not want to get entangled. My
No, no,
only,
this is my query only.
My lord.
As a counsel, as
My
an
lord.
officer of the court, I
My
am
lord.
putting a query. You are not defending private respondent.
my lord.
Your submission is that instructions may be given to the police to register a case
My lord.
without issuing any other relief. Without issuing,
Police will maintain the law and order, my lord, because once the FIR is registered, my lord, police will, and if anybody tries to, my lord, bring in disruption, my lord, the law will follow, my lord. The police will take action, my lord. Why police is there, my lord?
but you have not registered,
Not accepted also. my lord.
heard Mr.
My lord, that I have to take instruction, my lord.
I'm saying on oath you have said,
My lord, this is a, my lord,
and in the mail you lost me, see.
means, well, zero FIR. Once they have sent mail, it is registered, my lord, now.
No,
It has to be.
It has to subsequent access, the subpoena police we have mentioned.
Heard Mr. A.K. Saraf, learned senior counsel assisted by Mr. A. Goel, learned counsel for the petitioner. Also heard Mr. What is your name?
Arthur, my lord, additional senior government advocate.
Ardhar, learned additional senior government advocate representing respondent number.
नहीं मेरा तो हो गया. I just don't want to get anything.
Respondent number 1, 2, 3, 4, 5.
Six only, not registered.
Respondent number 1 to 5. This writ petition has been filed by the petitioners, under Article 226 of the Constitution of India for issuance of a writ in the nature of mandamus and oblique or any other appropriate order / direction / writ of the like nature. The facts relevant for consideration of the present writ petition, in brief, are that the petitioner is a tenant of respondent number 6 in respect of a warehouse which has been fully described in the, you have given schedule in the writ petition, fully described in the
Page number? Page number 19,
fully described in the schedule of the
page number 20, 9. Details, no? Details.
in the writ petition. During the subsistence of the tenancy between the petitioner and the respondent number 6, certain dispute arose between the parties, and respondent number 6 or 3,
Six.
respondent number 6 had filed an eviction suit which has been registered as commercial suit number 1 of 2023, which is pending in the court of learned civil judge number 1, Kamrup, Amingao. Stop. The said suit is fixed on 30/10/2024 for hearing on the question of maintainability of the said suit. Stop. Learned counsel for the petitioner, learned senior counsel for the petitioner has submitted that as dispute was going on between the parties regarding the tenanted premises, the petitioner had issued, where is that notice?
16/4, my lord.
It issued a notice on
Page 98. By page 98.
16/4/2024 for vacating the suit premises.
6 months notice.
The said notice was of 6 months, which was to be expired, to be expired on 16/10/2024. However, on
7th October,
7th October 2024,
page 120,
the petitioner,
128,
page
128.
again issued a withdrawal, issued a notice regarding withdrawal of notice for termination of tenancy, which was issued by the petitioner on 16 April 2024, citing certain reasons for the same in the said notice. Stop. On receipt of the said notice, the respondent number 6 on 8 October 2024 issued a communication whereby communicating the rejection of the withdrawal notice dated 7/10/2024 issued by the petitioner. It is submitted by learned senior counsel for the petitioner that in the notice dated 8/10/2024, the respondent number 6 had also directed the petitioner to hand over the tenanted premises to the respondent number 6 on 16/10/2024. And it was also intimated that no operation shall be allowed to be carried out from the tenanted premises from 16/10/2024 onwards. Learned counsel for the petitioner has also submitted that the petitioner also became apprehensive because of the language used in the said notice, said communication dated 8/10/2024, wherein it was stated by the respondent number 6 that the petitioner would be solely responsible for any kind of accident, untoward incident, loss of life, loss of property, any kind of violence or unlawful behavior on the part of workers of the petitioner's company or of Messrs. Or of the respondent number 6 company. Stop. Learned counsel for the petitioner has submitted that on getting the said learned counsel for the petitioner, senior counsel for the petitioner has submitted that since the notice for vacation was issued by the petitioner himself itself on 16/4/2024, it was open for the petitioner to withdraw the same, and no leave is necessary of the respondent number 6. More so, since a civil litigation in respect of the tenanted premises is pending before the commercial court. Stop. Learned counsel for the petitioner has further submitted that on being apprehensive of the intimidation used in the letter dated 8/10/2024 by the respondent number 6, the petitioner apprehend breach of peace in respect of the tenanted premises, and therefore it filed an FIR on 18th October 2024 before the officer in charge of
13 page
yes, 13. On 13/10/2024 before the officers in charge of Gauripur Outpost, Amingaon,
which was not accepted.
requesting for assistance on 16 October 2024 to maintain law and order in and around the tenanted premises. Learned counsel for the petitioner has also submitted that the said FIR was not received by the station house officer of the Gauripur outpost, and therefore the petitioner was compelled to file an email
Page 161 below.
to the Superintendent of Police Kamrup seeking assistance on 16th October 2024 to maintain law and order in and around these suit premises. However, it is submitted that police has not registered any FIR and no action has been taken in respect of the FIR as well as email filed by the petitioner. Learned counsel, senior counsel for the petitioner has also submitted that the petitioner also approached You went to the deputy commissioner office,
I myself,
then office,
office, 3 or 4 staffs were there. Then I called the deputy commissioner, but he did not pick up my call. Then I sent message.
And the reply was that I am out.
I will.
petitioner also approached the office of the deputy commissioner, Kamrup, for urgently moving an application under section 164 of Bharatiya Nagrik Suraksha Sanhita, 2023. However, the engaged counsel of the petitioner was informed by the police, by the deputy commissioner, that he was on leave till 17th. Learned counsel for the petitioner has submitted that under such circumstances, when a private dispute is pending between the respondent number 6, between the petitioner and respondent number 6, and when due to the acts of the respondent number 6, petitioner apprehends that there may be breach of peace requiring the involvement of state authorities, and when the state authorities have refused to register the FIR, as well as there is also no scope of filing an application under 164 of BNSS, as the deputy commissioner would not be available till 17th of October 2024. Under such circumstances, where relief is also sought for against the state respondent,
No, page 124 also, if you also mention.
a writ petition lies. Page number?
124, my lord, which he has put on the premises.
Okay. Before this last paragraph, learned counsel for the learned senior counsel for the petitioner, wherever counsel is used, senior counsel mentioned. Learned senior counsel for the petitioner has also submitted that the respondent number 6 authority has also put a banner in the suit premises, in the tenanted premises, whereby a notice is given, notice of no entry from 16/10/2024 is hanged, no, is given. Stop. He submits that such act on the part of respondent number 6 and inaction on the part of state authorities have made the petitioner more apprehensive regarding the possibility of breach of peace in the tenanted premises. Stop. On the other hand, learned assistant senior additional senior government advocate Mr. Ardhar has submitted that the dispute in the present case is a dispute between the private parties, and a writ petition is not maintainable. He also submits that the dispute is pending before the parties and before the petitioner and respondent number 6 in the commercial court, and the parties are free to seek relief before the said court. He, however, submits that considering the no, he also submits that he has to seek instructions regarding the allegations made by the petitioner regarding refusal of accepting FIR by the SHO Gauripur, as well as inaction on the part of the SP Kamrup on the email filed by the petitioner. Stop. He, however, submits that if an FIR has been filed by the petitioner, at best, at this stage, the said FIR may be directed to be registered and police may be directed to take appropriate action on the same. Before counsel for respondent, eta paragraph aru add kori diok. And its senior counsel for the petitioner has also submitted that under such circumstances, this court can invoke its writ jurisdiction and grant appropriate relief. And in support of his submission, he has cited following rulings. Number 1, Dibo, Krishnaram Mahale versus Shobha Venkat Rao, reported in 1989 for SCC 131. Number 2, Dibo, Mysore Machinery Manufacturers Limited, Bangalore versus State of Mysore and another, reported in 1967, SCC Online, KAR 75.
You know, but my satisfaction one more is there.
Next, Hindustan Motor Finance Corporation Limited versus Superintendent of Police and others, reported in 2019, SCC Online, Madras 2069. Stop. Now, the government advocate issue notice to the respondents. Since Mr. Ardhar has appeared for respondent number 1 to 5, no formal notice need to be issued to the said respondents. As regards respondent number 6 is concerned, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with heading as well as by usual mode within 2 days. Within 18th is open within 3 days from the date of this order. Returnable on November 6th. The date in commercial court is
30th.
Returnable on November 6th. Stop. The question of maintainability shall remain open. No, before that. However, in the meanwhile, considering the submissions made by learned counsel for the parties as discussed herein above, the Superintendent of Police Kamrup is directed to take steps for registering the FIR lodged by the petitioner on
No,
which
my lord, if lost, because they say that it was not, the police didn't accept the FIR, my lord. They have to now, my lord.
Mail was.
no, where is the FIR?
8156.
You mentioned in the mail also, my lord, that it was not accepted.
What was the last line? Petitioner on 13 October 2024, as well as taking appropriate steps on the email filed by the petitioner to the Superintendent of Police on 13/10/2024, and thereafter take appropriate steps as required by this situation, as demanded by the situation. Stop. The respondent number 6 is also directed to maintain status quo as regards the tenanted premises till the next returnable date. List accordingly.
My lord will indicate one thing, my lord.
The
They have to, my lord, now, maybe the police doesn't have that FIR copy.
We'll send it again by mail.
They have to now go and submit it, my lord. Otherwise, how they will act?
But today itself, we will do one thing, my lord, we will send by mail if the mail is there. SHO mail is there.
Because it is not with the police. They said they have.
No, today itself, our person will go and
the,
submit it.
the petitioner is, your mail is there.
No, my lord, we'll today itself, our person will go again to the office in charge and will submit it again.
The petitioner shall again submit a fresh copy of
same
the
copy of the
copy of the FIR, which was filed on 16th of October, 13th of October, to the Superintendent of Police Kamrup,
Along with the copy of the order of his honorable court.
along with the copy of the order of this court. Before that, one line, the question of maintainability is kept open.
My lord.
List accordingly.
My lord, although it is unusual prayer, but the copy of the order, if my lord, today it can be uploaded. my lord,
No,
then-
it will be,
And
because from tomorrow it is.
I know, my lord, your lordship.
আপনি চেঞ্জ করে দিও। বেলেক্স ট্রেন ওই জন্য তোকে আমি যাব দিও। অরূপ আপনি যাও বেলেক্স ট্রেন। It will be uploaded.
I do. I'm highly obliged. Lord.
Sorry for giving. It has to be, because from tomorrow morning again, I'm not available here in Guwahati.
He's going to Vaishnav Devi, my lord.
So,
Taking blessings.
so my lord, even I have to communicate, I have to also get the order, my lord.
So as soon as early as this court rises, it will be helpful.
If your lordship has, in the morning, from morning, your lordship is sitting now.
One more item is there.
He is sitting with Acharya Chaudhary. I'm sorry, my lord, again, once again, for disturbing your lordship in the vacations. I'm highly
Disturbance
obliged.
of both bench and bar. Bench and bar you are disturbing.
No, but in the vacations, disturbing your lordship. I'm grateful to your lordship.
No. What you say to me? I'm sorry, I think time is in the convenience of also. a person
Your matter is a transfer matter.
transfer matter. I made
So
a fact and my lord.
we'll issue notice, no relief, no
My lord,
interim.
your lord, kindly see, my lord, kindly just moment, my. What happened to me, my lord? Only 10 months something in the particular place, Morigaon.
No,
My lord, let me just.
okay.
Then I am going to retire also 1 year, 8 months or 9 months. Only my mother is psychiatric patient, brother is psychiatric patient, all the kind. I am heart patient. Now what happened against nobody, against existing against I have been suddenly transferred to Margate, about 600 kilometers. And here at Morigaon, I am here, madam, from Guwahati I go. I stay at my residence to take care of my
No,
mother.
but the authorities are at liberty to.
No, your lordship, before they must justify. Your lordship, kindly see the order, my lord. They must justify. If before 3 years, if they are to 2 years, they are to transfer me, that to justify that for what reasons. Now
How
you
long
can-
you are in Morigaon?
Only 10 months, my lord. Your lord, kindly see page 19, page 19.
But you have already been released.
No, your lordship, what happened, my lord? I have not yet handed over, I am the custodian, head of the office. Or to whom I am to hand over charge, nothing is there, my lord. Tomorrow, something will happen, my lord. I have stated that what happened, both transfer order as well as release order on the same day at 4:10 a.m. p.m. my lord. When I came from washroom, then I found on my table both. Transfer order is 18:09. I continued till 8:09, my lord. I continued in the office till 9.
How the state government's transfer, this is which department?
This is food and civil. Now it is consumer, my lord.
How the transfer orders are communicated?
Yes.
It
you
is
will kindly-
uploaded.
My lord will come to
Nothing.
page number 21, my lord.
I have categorically stated, my lord.
My lord, page number 21.
Yes.
This is the transfer order, my lord, dated 18/9/2024.
Right.
My lord, we are in December, 1 month gone in between. My lord will see it is marked to him in serial number 6. Bottom, my lord, in memo. My lord,
He will oppose for sake of opposition, madam. Your lord, kindly see.
No, my lord.
paragraph 6, madam. It is my turn.
Yes,
This
that
my
is true.
turn.
That
It is
is
not your turn.
Yes.
Yes.
But your time is very less.
No.
So if
My
you
lord,
take
we have
full
come.
time,
It is not my pleasure to come before lordship. Compels my necessity has compelled me to come into my lord to cause inconvenience to your lordship.
no, but his submission is you are late.
No, my program, I have not received it till today officially, my lord. It is my awardment, your lord, kindly
Okay,
see.
then
Paragraph
how
6.
this is communicated?
Yes, paragraph 6, your lord, kindly.
My lord, it is done only.
Please stop. Paragraph 6, your lord, kindly, sir.
Para?
Paragraph 6.
Yes.
Petitioner begs to state that though he was stated to have been transferred a notification dated 18/9/24 and posted on Margarita, but he continued to discharge his duties till Morigaon till 9/10/24. You will kindly note. And during this period, 18/9 to 9/10, neither he received the transfer order dated 18/9/24, nor he was communicated the same by any other means. To his utter surprise,
When you received the transfer order?
next page, to his utter surprise, your lord's kindness. On 9/10/24 in the afternoon at about 4 p.m., he went to washroom, and when he came back from washroom at 4:10 p.m., he found a copy of the release order along with a copy of the notification dated 18/9 on his table. When he asked his peon about the same, peon told that petitioner that someone from DC office came and kept the same on his table and went away without waiting for the petitioner and also without taking signature of the petitioner. However, on perusal of the notification dated 18/9, it appears that the petitioner was shown to have been transferred from Morigaon and posted Margarita Tinsukia in the same capacity against a vacant post. And by the other order, he was shown to have been released from the office of Morigaon on 8/10 to join the new place of posting.
Who has been posted in your place?
No, none. None pushed against me, nor any against anyone I have been posted. And you must kindly
But
see.
normally transfer orders are interfered only if there is some
Exactly.
malafide or some arbitrariness is there.
Then you will kindly see, my lord. Malafide, I am coming, my lord. You will kindly see page 23, my lord. An honest officer, my lord, page 23. Only his problem, he made a complaint against one MLA and his supporter. They have manhandled him in the office, my lord. I have given complaint on Deputy Commissioner 29/2/24. Within 2 months of my transfer to Morio. Then you must kindly see appreciation letter by the Deputy Commissioner, page 27. But the election was over on 4 June 2024. Thereafter, this letter is issued by the DC. I recommending my service.
No,
and-
what is this letter?
Yes, you'll kindly see, madam. Deputy Commissioner writing to me. He is head of that department in the district, madam. I am writing to express my heartfelt gratitude for your exceptional dedication and unwavering commitment as one of the leading officers of the refreshment cell during the recently concluded Lok Sabha election in Mogigaon district. Your tireless efforts and meticulous planning in so and so, so and so, so and so, so on.
No, what is this?
This shows that, madam, no complaint, nothing at all.
What is the content of?
Oh, content the letter is that, my lord, during the election time, I have been assigned some duties. This Lok Sabha election, madam.
Okay.
So I have been assigned some duties. I have done very wonderfully. I have done it. Tirelessly I have done. So he has issued a commendable letter, appreciation letter.
But that may not be a ground for not
No, I'm
transferring.
not saying. I'm not saying. Transferring may. They have right to transfer me. Now, two things here, man. One thing is that 3 years not completed, only 10 months. For that you have to
But
justify your-
administrative exigencies may be
No,
there.
what is that? Against nobody is there, madam. None is posted against me. No, somebody is there, madam. What is administrative exigency, madam?
No, that.
What is the circular says, madam?
Administration may be knowing.
No, what? They must disclose, madam. They are not issuing, there are not a single piece of paper that I have received it, madam. This office is hardly within 1 furlong, madam. And just like a person is that came, unknown person came and kept it on the table and he went away. And both release order and the transfer order is on the same day. And my transfer, your lordship, kindly see this petitioner, madam Margarita, your lordship very much aware of that, madam Margarita, madam. About 6 kilometers, 600
To
kilometers.
whom you will hand over your charge?
That is also not there. Your lordship, kindly see, nothing is there. I am the custodian of the records. Your lordship, kindly see, nothing is there. Page 21. Transfer order. Then page 22. Release order. That's why on 9 also, my lord. 8 release order. On 9 I continue in the office. Yesterday also he has gone to office, my lord. Because they have not given me to whom I to end my charge, my lord. Once I go without that, my lord, they will again come with a complaint.
Just a moment. To whom he will hand over charge?
My lord. Page number 22, my lord. This is the release order, my lord. My lord will come to the bottom, my lord. Received on 4/10. The petitioner has already received it. Thus, my learned senior is submitting that he doesn't know, somebody has kept it on his table. But here it is signed by the petitioner that he has received.
I made a statement. I received it.
He received. And my lord, the page 21.
What is the designation of the petitioner?
Assistant Director of Supply, Food and.
So whether he has to hand over charge to somebody?
My lord, DC has already taken over the church, meaning thereby, my lord. Because DC, my lord, this assistant director, he is always attached to the deputy commissioner in the district, my lord. My lord, district commissioner, he is the overall in charge of a district. He looks over, my lord, every department that has been assigned in the district. So assistant commission director, my lord, obviously is within the jurisdiction of district commissioner. So here, my lord, district commissioner has unilaterally, my lord, has released him, my lord, meaning thereby he has taken over the church. And my lord, before that page number 21, that he is very late, my lord, to come to this court, my lord.
No, but his assertion is that he received this order as well as release order on 9/10.
At 4.
My lord, this is my lord is well aware that Assam government has gone totally in E mode.
Therefore, I was asking.
Exactly, my lord. That is what I want to show, my lord. Page number 21.
Whether it is uploaded somewhere.
Yes, my lord. That is what this is. My lord will find this on the top. There is a, my lord, number. This 7/2022 supply. These are, my lord, E numbers, my lord, e-filing numbers, my lord. And this signature is also, my lord, that is e-signed.
Then you seek instructions.
And my lord, this goes, my lord, this is an, my lord will find the notification is number ECF, that is through e-portal, my lord. So, my lord, this will go straight to his email.
I continued till 9, my lord. If this is there, my lord. I stayed on oath, my lord. Both letter I received on 4:10 PM.
No. But if the notification is uploaded in website.
No,
if that
website,
is-
my lord, it must be, there is a procedure, my lord. I must receive, I have stayed on oath. Nobody has communicated to me that what I have given. Neither it is communicated, nor it was served upon me.
Now,
I received the
now two
only
things, my
on
lord.
9, on 9 at 4:30 or 4:10 PM I received it. And how I continued, my lord. I continued till yesterday, I continued.
Now, my lord, two things, my lord, have to take into consideration before passing any order, my lord. He has been released.
Oh, that is there.
He has been released, meaning thereby he is not in the office.
But you
My
told
lord,
me,
before quashing it, my lord cannot bring him back. My lord has to quash these two orders first.
on 9,
My lord, release order cannot, he has been released. He has missed the bus.
you are not the first time, I think you are here for a long time, you are practicing.
My lord, he
You
has
know the
missed
court
the
can
bus.
exercise when it is found arbitrary and nullified.
My lord, he has missed the bus. Unless my lord quashes this order, my
No,
lord.
where is the arbitrariness?
Where is the arbitrariness, my lord?
First 10 months only against anybody. Back and forth. What is the accident?
Malafide, he has to, my lord, bring, who has done malafide?
Yes, your lordship, if a court come, your lordship will find.
He has to be made a party by name.
No, I have not by name. I'm
Then-
simply say an MLA. That
No, my lord. Supreme Court is very
because
clear.
Courts will reveal, my lord.
Transfer orders, courts are reluctant to interfere.
That's
Unless
but
there is,
interfering, my lord. Your lord kindly see the judgment I have given.
no, unless there is some malafide,
So your lord, no, arbitrary, nullified arbitrary and violation of the own
how it is
guidelines.
arbitrary?
Violation of their own guidelines, my lord. Your lord kindly see this judgment, your lord kindly see.
Violation of the
Own guidelines,
policy,
own their own official.
but for administrative exigencies.
In the interest of,
Why are it must be there, my lord.
my lord,
There
If
is the order.
somebody is there,
My
suppose
lord,
somebody is posted against me.
in the order
All right,
itself.
I understand, my lord.
No, it is there in the order. In the order, the opening line is
In the interest of public
interest.
No
service,
problems, my lord.
paramount.
In every mount, my lord.
We are issuing notice.
No, but it's up to your lordship, my lord. But the things is, my lord, people comes not with the pleasure, my lord.
Without
With some
any
necessity, my lord.
My lord will not issue notice, my lord. I have no issues.
Notice there is no problem, my lord. My friend, where I am now,
He has
where
been-
shall I go, my lord?
He has
To whom
been
I should
released.
hand over charge? Your lord's kindness, paragraphs, my lord, there, just page 8, my lord. Page 7, paragraph 7. Custodian of the records, my lord. To whom, my lord, kindness, page 7. Though the MP notification,
You have sought instructions. You will be seeking instructions, any instructions. You will be filing.
My lord will issue notice, we will file affidavit, my lord.
in the meantime, what will happen to me?
My lord, he has
Court
been
is
released.
closed.
He has been released, my lord. Deputy Commissioner on his own, my lord, the district commissioner has done it, my
Nobody
lord.
has been posted against me.
My
No,
lord,
against
that is not his,
somebody is there.
that is not petitioner's lookout, my
No,
lord,
there
who has been,
prejudice, my-
in the interest of public, my lord, he is a government servant, he has to go.
This type of government advocate I have never seen, my lord. For the sake of opposing, he's opposing my,
Heard,
what type of things you're doing?
heard Mr. H.R.H. Chaudhary, learned senior counsel assisted by Mr. A.M.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. R. Dhar, learned additional senior government counsel representing
Here, my lord,
representing
all, my lord.
all the respondents. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner impugning the order dated 18/9/2024 issued by respondent number 1 from by transferring and posting the petitioner at Margherita in Tinsukia in the capacity of Assistant Director, Food and Public Distribution and Consumer Affairs. The petitioner is also aggrieved by the order dated 18/10/2024. 8/10/2024, passed by the respondent number 3, whereby he was shown to have been released from the post of Assistant Director, Food and Public Distribution and Consumer Affairs, Morigao, where he is presently posted. Stop. Issue notice to the respondents. Since the petitioners are responded, and since the respondents are represented by learned additional senior government advocate, no formal notice need to be issued. Learned additional senior government advocate seeks some time for filing an affidavit in opposition in this case. The prayer is allowed. Let this case be listed again on when, how much time will you?
My lord, 2 weeks, my lord.
On 8th of November 2020.
This book, my lord.
You want a shorter date?
Certainly, my lord. Why I have come before worship, my lord.
On 28th of October, 28th of October 2020.